Good afternoon, ladies and gentlemen. The Appellate Division, First Department is now in session. As a first order of business, I will be calling the calendar. I'm going to ask you to please respond when your case is called with your appearance, and then I will confirm to you the time that's been allotted for your argument. The first case is People versus Carrion.
Yes, good afternoon, Your Honor. Whitney Elliott of the Legal Aid Society for the appellant Ramon Carrion.
And Christopher Peterson for the People, Your Honor.
Thank you. And the time allotted is 4-1 for the defendant and 4 for the People. Hudson Spring Partnership versus PM Design. Edward Weissman.
The respondent's here, Your Honor. I don't know where Mr. Weissman is.
Well, I understand that he was on previously. Do you have any way of reaching him?
I could only call his office number. I don't have any other way to reach him besides that and email.
All right, I think those are good ways to reach him. So I am going to just indicate that it's 5 and 2 and 5, and please call it Mr. Weissman, and we look forward to having him part of the session.
I'll do that, Your Honor.
Thank you.
Your Honor, it's Edward Weissman. I'm here.
Oh, good. All right. All right.
I
So you have 5 and 2 for your argument, and Mr. Feingold will have 5.
Thank you.
Thank you. Thank you. Eddie versus Sylvia. Eddie S. versus Sylvia S. Submitted. Pritzker versus Szymanski.
Mark Hausman for defendant respondents, Your Honor.
And you have 3 minutes, sir.
Thank you.
Victoria's Secret versus New WTC Retail.
Mara Levin of Blank Rome for defendant appellant.
Good afternoon, Your Honor. Allison McKinstry for plaintiff respondent Victoria's Secret.
Good afternoon. The time allotted is 5 and 2 for the appellate and 5 for the respondent. People versus Pena, that's submitted. International Development versus Westchester Plaza.
Good afternoon, Your Honors. Edward Vincent with Borchard and Laspina on behalf of the defendant appellant.
Good day, Raymond Schwartzberg for plaintiff respondent.
Right, and the time allotted for argument is 5 and 2 for appellant, 5 for respondent.
Yes.
Ubilis versus Nagar Dingabi, and I'm sorry if I mispronounced the name.
For the appellant, Paul Gruber, Bora Goldstein.
Good afternoon, Your Honor. Fern Flomenhaft for the respondents.
And the time allowed is 4-1 for appellant, 4 for respondent. BGR Realty versus Stein.
Good afternoon, Your Honor. Jean-Pierre Brutus, Bronx Legal Services. For the appellant, Mr. Michael Stein.
Paul Gruber for the respondent.
And the time allotted is 5-2 and 5. Brunert versus American Built Right. And that will be argued with Dyer versus American Built Right.
Yes, hello, Your Honor. This is Justin Reinhardt for defendant appellant American Built Right.
Ms. Golansky. She was apparently on before. So, Mr. Reinhardt, I'm going to ask you to please try and contact her and invite her to join us online again. But the time allotted for the argument.
I'm sorry, Your Honor, I'm here. I think I was still muted. This is Alani Golansky for Brunert and Dyer.
All right. Thank you. We're glad you joined us, or that you're still here. All right. On both cases, it's 10 and 3 for the appellant and 9 for the respondent. In the matter of Darrell W., that's a submit. People versus Rivas.
Good afternoon, Your Honor. This is Vatsala Sahai from White & Case. Together with Legal Aid Society, we are pro bono counsel for appellant, Mr. Grilzo Rivas.
Good afternoon, Your Honor. Megan McLaughlin for the people.
And the time allotted is 6 and 2 for the appellant, 6 for the respondent. American Empire versus LNG Masonry.
Good afternoon, Your Honor. Maureen O'Connor for Appellant American Empire.
Good afternoon, Your Honor. Allison Drachman, counsel for Respondent, Cross Appellant Mega Contracting.
Good afternoon, Your Honor. Brian Forbes for Defendants, Respondents, Cross Appellant St. Augustine.
All right, and the time allotted for this case is 6 and 1 for the appellant. It is then 4 and 1 for both the respondent and the respondent appellant.
Thank you, Your Honor.
Thank you, Your Honor.
Mullins versus Centerline is submitted. Burlington versus Tor Central is submitted. People versus Saladin.
Good afternoon, Your Honor. Ray Koshetz for defendant appellant Elijah Saladin.
The people, Ms. Cohn. Beth Cohn.
Good afternoon. I'm sorry, it went back to mute. Beth Fish Cohen for the people.
All right, and the time allotted for that case is 6 and 2 for the appellant, 6 for the respondent. Dyer versus American Built Right, that'll be argued with the Gruner case. 32 Jabez versus Mekong, it's submitted. Mortgage Electronic Systems versus Mikado is submitted. Lou versus Tiedemann.
Good afternoon, Your Honor. Eric Fishman for the appellants.
Good afternoon, Joel Taylor for appellees.
Good afternoon. The time allotted for your argument is 5 and 2 for the appellant, 5 for the respondent. All right, we'll hear from the first case being argued, People versus Carrion.
Yes, good afternoon, Your Honor. May it please the court, Whitney Elliott of the Legal Aid Society. We ask this court to reduce Mr. Carrion's sentence, whether as a matter of sentencing entrapment, due process, or by finding it excessive, because the only relevant conduct here involved the
What is sentencing entrapment?
sentencing entrapment. It sort of originated where a defendant was predisposed to commit a lower level offense, but was later induced to commit a higher level offense that the defendant would not have otherwise committed absent the inducement.
First of all, is that concept, I've never seen that applied in the state jurisprudence. And what about your waiver of appeal?
So a couple things in terms of the New York case law, it hasn't been either accepted or rejected or even addressed in any way.
A good way to put it, it hasn't been accepted or rejected. It just really hasn't been accepted.
Well, I don't think it's been addressed in any way or even rejected. And as we point out in our reply brief, the concept does have due process origins. And the Court of Appeals in People versus Isaacson held as a matter of due process when there was entrapment-like conduct on the part of law enforcement, it could not only reduce a sentence, but it could dismiss a conviction and indictment outright.
You can't compare the facts of this case to People versus Isaacson. Isaacson's a seminal case and the facts are very much more extreme.
Well, a few points on that, Your Honor, and I just disagree. I mean, on a few different points, they are different. But in Isaacson, I think one thing, the defendant himself obtained the drugs that were sold. That's not the case here. They were provided by a confidential informant. The defendant in Isaacson was predisposed to sell drugs, although smaller amounts, because he had done it before.
He was beaten by the police too.
He was not beaten by the police. The informant had been beaten by the police, and that was the dissent took issue with that and said the defendant here wasn't even beaten. He was just induced by a CI. The defendant himself was not beaten. The defendant himself had been a smaller scale drug dealer and was later induced by an informant who had been beaten to sell much larger quantities of drugs. And the defendant himself obtained those drugs and sold them to the police. Here,
but there was a fear of physical intimidation in that case.
I don't think there was, Your Honor. That was just the the confidential informant was playing on the defendant's sympathies. There was no physical intimidation, and the dissent in Isaacson took issue with that and said all the physical intimidation here went to the CI, not to the defendant. And again, I think we have stronger facts here because that Mr. Carrion did not.
Can you explain how these are stronger facts when you have 3 sales of guns in February, 1 in May, 2 in June, 2 in July, and 1 in August? Why would this be a stronger case?
Because, Your Honor, in Isaacson, for example, the defendant himself independently obtained the drugs from sources other than a confidential informant and from sources other than the police. Here, the only contraband that was involved was contraband that a confidential informant himself provided to my client. My client, and also in Isaacson, the defendant himself was selling drugs, lower levels, but was selling drugs independently of the CI. Here, Mr. Carrion was not involved with guns in any way before he was induced.
We know that merely affording a person an opportunity to commit a crime is not entrapment. Where's the active inducement here? Where's the encouragement here?
Well, we think that the record shows my client said he was paid. He did this because he was paid. And I think the record strongly suggests
why does that make it active inducement or encouragement? Just getting money to commit a crime is active inducement?
Yes, and if I could, I just want to clearly distinguish this from the mere opportunity concept that Your Honor addressed. This is not like a case like People versus Brown, where an undercover officer just asks a defendant, are you willing to commit a crime? Here, the question is, are you willing to commit a crime if I pay you? And so the payment is the inducement, and that's why this is not mere opportunity. The mere opportunity concept, as sort of articulated in Brown, is just asking, will you do this without offering any inducement? Here, there is an inducement.
Yeah, this is Judge Gish. I would wonder if you would answer Judge Mazzarelli's second question to you, which is why isn't the waiver of appeal, why doesn't that cover your ability to make this argument about sentencing entrapment?
I think 2 responses, Your Honor. One, even assuming the validity of the waiver, a waiver would only cover a pure excessive sentence interest of justice claim. It would not cover a due process or sentencing entrapment claim, because we think that kind of claim goes to it's based on constitutional due process, the constitutional permissibility of the sentence. And
well, don't you have to preserve constitutional claims? Was this preserved?
Well, this claim is not preserved, but there is an exception to preservation for a claim that relates to the legality of a sentence and that can be resolved on the face of the record. We think that the record here is adequate to adjudicate that claim on the merits. But in terms of the waiver itself, as we argue, it was never informed that he had a right to appellate counsel, either in the oral colloquy with a written waiver. We don't think did it. The other side doesn't really argue that the oral colloquy informed him of that right. They just say, oh, they're just not required to do so. So those would be my responses, that it survives.
Thank you.
This is Judge Mazzarelli. Just one thing. You refer to sentence entrapment. I think entrapment refers to the commission of the crime, and I think in your brief you called it sentence enhancement. Am I? Didn't you speak about enhancement?
I don't. I mean, there are sort of mixed concepts: sentencing entrapment and sentencing manipulation. Sometimes they're distinguished, sometimes they're treated as one and the same concept. We don't think that the label here is really what matters. We just think that here, when we think that where the record shows that he wasn't engaged in any kind of conduct before the government became involved or afterward, you can be pretty certain that if, quote, left.
Well, I guess my point is that entrapment goes to the guilt of the offense, where the sentencing issue is in a different posture.
Well, I agree, Your Honor. I mean, I think we're not even acknowledging the sort of lower level form that he was predisposed to commit a lower level offense. We have the fundamental point that I think the record here shows he wasn't predisposed to commit any of this, but we think those same facts would also submit the much more modest relief of a sentence reduction rather than outright dismissal.
Thank you. Let's hear from Mr. Peterson.
Christopher Peterson for the Office of Darcel D. Clark. Good afternoon, Your Honors. In this case, the defendant sold 20 guns, including handguns, defaced weapons, and loaded weapons to undercover officers over a period of several months. Under the circumstances, he negotiated a fair plea bargain where he received a fair sentence of 4.5 years and 2.5 years of post-release supervision for that conduct, and he waived his right to appeal, which precludes review of his sentencing claim. But I'd like to take a minute to address his allegations that he was the victim of entrapment. There is no evidence in this record that the defendant was induced or cajoled into selling guns. It is also not clear on this record when the confidential informant actually became a cooperator. The record merely reflects that the defendant was introduced to undercovers by the CI, that the defendant sold 20 guns between February 10th of 2017 and August 13th of 2017, and that the confidential informant was arrested sometime in mid-August of 2017.
So you mean to tell me we don't know if all of these sales involve the confidential informant? Wouldn't we know that?
Well, we do know that the confidential informant is the one who introduced the defendant to the police here. That is clear.
Did he provide the defendant with the weaponry?
That's what the record says, yes. However, the defendant didn't make any entrapment claim below. He was advised that this case involved a confidential informant, and nevertheless, he decided to plead guilty and in exchange for the sentence imposed. And he validly waived his right to appeal in connection with that plea bargain.
So, counsel, this is Judge Owing. So you're telling me, let me see if I heard you correctly. You're saying that the confidential informant became a confidential informant after the fact?
No. What I'm saying is it's not clear on this record when the confidential informant became a cooperator. We know that the defendant was introduced to the police by the CI, but I don't know exactly when it is that the CI became a cooperator.
Well, we became a CI in a sense,
That's
right?
correct.
So that there was a point in time where the defendant and the CI were doing business together, but we're not sure exactly what point in time did the CI actually become a CI.
That's right. It's clear that he was arrested in mid-August of 2017.
After he had already completed some transactions with the defendant.
Yes, and in fact, after all of the sales, it would appear, because the last sale for which there was, charged conduct in this case.
Oh, I see. So you're saying that the record is indicating that there's a factual basis for the argument that the defendant and the quote-unquote CI at the time, they were just doing business together without him being actually the CI.
Yes, there's a factual basis for that assumption, but it's not clear, Your Honor.
It's not clear. I got it. Okay.
Thank you.
At a minimum, it's not a matter of law. You can't just decide this as a matter of law as the appellant is arguing.
That's correct, Your Honor.
Okay. Got it.
And if Your Honors have no further questions, the people ask for an affirmance. Thank you.
Any further questions, colleagues? All right, Mr. Elliott, you have some time in rebuttal.
Thank you, Your Honor. Just one quick point on the adequacy of the record. I mean, the disclosure letter here and the protective order application here, they don't spell out the details in terms of when, but I think it's pretty clear a reasonable inference, and I think the only reasonable inference, that what happened here was after they arrested my client, they bring the prosecution brings him in for a proper session. He says, "Yes, I got these guns from the
Let me
CI."
stop you for a minute, but isn't this where maybe the issue of preservation might have helped your record? Because we're a bit confused about whether some of these transactions were not the government selling to itself, as you claim, and certainly had the issue been preserved below or raised below, that would have been fleshed out, right?
For sure, Your Honor. But I mean, again, I mean, this issue about the timing, I think the record pretty clearly shows what happened, Your Honor, with respect in terms of a reasonable and non-speculative inference about what happened.
But counsel, this is Judge Ong. Do you disagree though that, as my colleague Justice Gish says, if in fact the defendant was transacting business with the quote unquote CI at the time that individual was not a CI, but they were just doing business together, selling guns, that you won't have an argument. Your arguments about the two issues you're raising won't go very far. I mean, are you disagreeing with that fact scenario?
Well, there wouldn't be a pure, I think it would be it would be a different claim. We would still have just a pure excessive sentence claim.
Yeah, you still have an excessive sentence claim, but your excessive sentence claim is based on these two theories that you're putting forward that are not, as you argue, a matter of law that we can decide, but it's very fact determinative now as to exactly what was the relationship between the defendant and the individual, quote unquote, the CI here. And when did the CI actually become a CI, and what he was getting the guns from? Well, that's all very important to know, right? I think.
Well, in terms of where the CI was getting the guns from, I don't think matters to this, but I agree. There could be more facts. I won't resist that, Your Honor. But I think our main point is a non-speculative inferences that can be drawn here are that Richardson was working as a confidential informant for the NYPD. Without telling them, he was giving Mr. Carrion guns to sell back to the NYPD.
I hear what you're saying, because the CI, quote unquote, he could be getting the guns from the police, right? But at the time, he probably didn't know he was getting guns from the police. They were undercover. So that's where it becomes, to me, important to know, well, at what point when he was getting the guns from the undercovers, was he part of an operation that the government was running? Or did he just not know that he was dealing with undercovers when he was getting those guns? That's important to know too.
So I mean, I think what was happening, again, I think the reasonable inference is that I think what was going on here, my reasonable inferences from the record, non-speculative ones, I think, are that Richardson was in effect misleading the NYPD. He was giving Mr. Carrion Richardson's own guns to sell to the undercover officers. When Mr. Carrion came in for a proffer session, he pointed this out to the prosecution. He said, "Yeah, Richardson was giving to me." They said, "Oh no, this is not what we this is not what we realized." That's what prompted them to make this disclosure. They realized Richardson had been misleading them, and this all along he was giving Mr. Carrion his own guns. He wasn't diverting guns from the illegal gun market. Thank you, Your Honor.
Thank you. Right, the next case is Hudson Spring Partners versus P&M Design. Mr. Wiseman?
Yes, good afternoon, judges. Edward Weissman, attorney for appellants. In this case, the landlord intentionally discarded evidence after suit was commenced by it.
Didn't you, this is Judge Gish, didn't the judge provide you a remedy for that? She gave you a spoliation remedy, right?
Your Honor.
She had an adverse inference. Isn't that a permissible remedy for spoliation under our jurisprudence?
Your Honor, she gave us a meaningless adverse inference. She said, "I'm giving you an adverse inference," and then never applied the adverse inference and never connected the wrongdoing by the plaintiff with the effect it had on our ability to establish constructive eviction and to establish our counterclaim.
Causation for the eviction, that was something that you had to separately establish, even if the adverse inference otherwise established that there were conditions at the premises that were less than optimal.
Your Honor, when someone discards evidence after suit is brought, and if someone conceals evidence, which we found out at trial, the principal of the plaintiff directed that the files be put in a warehouse in Queens.
I'm aware, but here's what I'm having some problem with, Mr. Wiseman, and maybe you can help me out, is that there was spoliation. The judge found there was spoliation. My understanding is that it is within the trial court's discretion about the remedy to be applied. And we review it in the capacity of an abuse of discretion. And what I'm trying to understand is why what the trial court did was an abuse of discretion. That's really where I'm having some analytical problem here.
Judge,
So go ahead, explain to me.
When a party goes out of their way to destroy evidence and conceal evidence, if you want to say that I didn't prove constructive eviction, I think that's unfair because I was deprived of critical evidence intentionally by the plaintiff. Frankly,
so this is Judge Owings. So counsel, am I tend to take your argument is that this case should have been dismissed then? Just based on that adverse inference alone, you should have won and prevailed and the case was over.
At least the plaintiff should not have been rewarded for their criminal-like behavior by getting a substantial judgment. That, at a minimum, that's where this should have been. The amended complaint should have been stricken. Instead, they engaged in serious...
So the bottom line, counsel, that's a long way of saying, yes, the case should have been dismissed.
Yes.
Right?
Yes.
So that would mean then you would not have to prove your counterclaim for eviction then. Right?
That's correct. And the judge even found that they did not provide any evidence to refute our presentation of evidence that of the condition of the place. She said, you offered nothing. So on one hand, she gave me an adverse inference. On the other hand, the adverse inference she gave me was essentially a meaningless one. And she also, judges, did not explain how she reached the point of saying, well, I'm only going to make an adverse inference. There was absolutely no explanation for her decision.
Counsel, this is Judge Owings. Did you think about when you got the adverse inference that maybe you should have withdrawn your counterclaim for eviction then? Because at that point, there would have been nothing to try then, right? The case would have been over.
Your Honor, if I could do it over, I'd have you as my co-counsel. That would have been...
Thank you for the boost of confidence. Because, I mean, you in a sense, I mean, Supreme Court had to go forward with your counterclaim. I mean, unless you were going to withdraw it.
But they didn't have
to. Separate tracks. Those are two separate tracks.
But Judge Owings, the judge did not have to give a judgment to a party such as this plaintiff. Had she simply denied them that and not give me...
I understand what you're saying. I hear loud and clear what you're saying, but the rub here is that you did have a counterclaim to try, so that unless you were going, your Supreme Court would have been it was in a pickle in the sense that, okay, I gave you an adverse inference, but unfortunately, I got to go forward with your counterclaim, and that's where you're saying, no, she should have just stopped there, and I should have won, and that was the end of it.
Judge, what should have happened is the plaintiff should not have been rewarded for its wrongdoing.
All right, I get that.
That was very clear on this record, and the trial judge was unanimously reversed by the First Department in the...
I'm going to ask you to wrap up. I'll let you answer Judge Gonzalez's question, but you are out of time, so that'll be the end of your argument.
Right. So counsel, I'm unclear as to how the records would have helped you with respect to constructive eviction, because presumably they would have shown that repairs were actually done. With respect to your burden, since you were in possession up until the day before you began a lease, I believe, at another location, how does that establish constructive eviction? If I remember correctly, There was testimony that your client had been looking for an alternative space for many years.
Well, there was testimony that they were looking for alternative space because of the conditions that were present. Your Honor, the first question, if you could just summarize it again.
Don't worry about it. We can just move on because I know we're beyond your time.
Your Honor, if I could just answer that question.
No, you can't answer the question that you don't know what was asked.
No.
And you're over your time, Mr. Weissman. We really
We'll talk about it on rebuttal. Don't worry about it.
We'll have some time on rebuttal. Please, let's hear from Mr. Feingold. Thanks.
Thank you.
Yes, Your Honor. Good afternoon. Joshua Fingold from the Law Office of Alan Berlowitz for the respondent, and may it please the court. Your Honor.
How do you answer your adversary's contention that the adverse inference that they got because your client spoliated records did absolutely nothing in this case? It had no effect on this case. Does that make it illusory?
Well, first of all, Your Honor, first of all, this issue was a discovery issue. It should have been raised before the note of issue. Notice he only talks about.
That's not true. That's not true, and I don't think you ought to rest your hat on that. Okay, it's an evidentiary issue at trial. She gave you the adverse inference, and it had effect on the burdens of proof at trial. Absolutely. So let's look at it from that point of view.
Yeah, yes, Your Honor. Well, first of all, Justice Crane, in reaching her decision, found that this was not the reason they left. And if you look at the record on appeal at page 726, the principal of the appellant states that one of the reasons they left was the configuration of the building and the size of the space. That's the real reason they left. Now, if Your Honor considers that under the lease, they had the right to cancel the lease by providing notice when they closed on the new property, that clearly shows that the real reason they left was nothing to do with the conditions of the space. Moreover, these records about the maintenance of the property could only have helped the plaintiff in this case. The plaintiff is under no obligation.
Wait a minute, Mr. Finkel. That's the whole purpose. You got an adverse inference against you, so you can't tell me that they would be helpful to you. There was an adverse inference that they are not helpful to you, that they would show that your client did not maintain the building.
Well, Your Honor, first of all, Justice Crane correctly held that in a commercial lease, the plaintiff is under no obligation to maintain the building. Mr. Weissman, in his papers, cites repeatedly to residential cases and loft law cases. This is a commercial case. And the real issue here is that even if you accept everything that the defendants are out of the space, it's still not constructive eviction.
And that's, they have to leave the premises, right?
Yeah, they had to leave the premises.
Caused by the conditions.
Yes, and also, Your Honor, the conditions have to be such that it meets the definition of constructive eviction. Mold, water leaks, and the presence of vermin, which, by the way, were the...
There's got to be a causation between the conditions that existed and leaving the premises.
That's 100% right, Your Honor.
I don't think there's a litmus test to articulate, it can only be mold, but it can't be something else. It depends on what the premises are and what they're being used for, right?
Well, Your Honor,
never mind, I withdraw the question.
So, Your Honor, though, but I would ask the court to consider that when the principal of the appellant was asked why he left, he talked about the size of the space. In his deposition, he talked about Wi-Fi. He talked about the configuration of the space. They had been looking for space for 10 years and had. So
I have a question, but I'm going to defer to Judge Oing, who's trying to ask you something first.
So, counsel, real quick, the argument by the appellant was that once you got the adverse inference against you for spoliation of evidence, that should have been it. You're not entitled to. The court should not have awarded you damages. How do you respond to that?
I think That's completely wrong, Your Honor. And respectfully, what I would say is that the judge is supposed to weigh the different remedies and come up with an appropriate solution. As was pointed out, the standard is abuse of discretion. And what Justice Crane correctly held is that the maintenance of the building isn't relevant to the issue of why they left. And why they left was not the conditions of the building.
Okay. Thank you, Justice Gonzalez.
Any
I'm-
further questions?
I'm good, thank you.
Okay, why don't we hear from Mr. Weissman on rebuttal?
Yes, I'd like to respond to Justice Gonzalez's question. I would start by indicating that the only documents that were concealed and the only documents that were discarded were documents that would have been relevant to the issue of whether or not the landlord properly maintained the property. That is very important. Secondly, why did they discard those documents and why did they conceal them? Well, likely because if those documents had been produced, they would show proposals made by various contractors to remedy the serious situations at the building. That's why they got rid of those documents. That's why we have serious spoliation, and the decision by the court below, if it's allowed to stand, will turn law from the Court of Appeals and
Mr. Weissman, this is Judge Owen, but assuming those documents that were destroyed would have demonstrated or were documents that you needed. Let's just say that they are documents. They were the smoking gun. Let's just say that those documents that got destroyed. Okay, the testimony that was put before the court with respect, which then support your counterclaim of eviction, constructive and actual. Okay, let's just say that that's that. You put testimony where the court had to weigh the evidence of the testimony from your clients with respect to all the other scenarios that were going on that Justice Gonzalez was sort of intimating about, in terms about how you did renew your lease, even though you had your problems with the building, that your clients were thinking of moving away and moving out to another place, and that immediately, I think it was like the next day or a few days later, after you bought the other place, you were out of this place. So, that was all being weighed. So I give you the thing that those documents that were destroyed would have supported your counterclaims, but then you had the other evidence come in that sort of took away a little bit, took the bite away from that evidence. So how does that all play out then?
Because none of that relieved the landlord of the obligation not to destroy evidence which it had a duty to preserve. And I would also point out,
I guess the question, I hear what you're saying. You're saying that we have to punish, if you spoil evidence, your punishment is you get no damages. That's what you're saying.
And you don't reward people who engaged in criminal-like behavior. As a final,
I would.
You're actually out of time. Ooh, so.
I wouldn't go so far as saying spoliation is criminal behavior. That's kind of, you're going to have every civil practitioner, jump up and down, say, "Whoa, wait a minute."
Your Honor,
your rebuttal time is concluded. So
thank you.
Thank you. We do understand your arguments. Thank you both.
Thank you.
Pritzker against Zemansky. Mr. Hausman, it's just you.
It's just me, Your Honor. Thank you. Good afternoon, judges. I don't wish to burden the court with a solo argument. Normally, I would submit. I just think it's ironic, and I make one quick point that if a party is unhappy with a lower court decision, the proper remedy is to appeal that decision. Here, we have a situation where there was a case. It was dismissed on a motion to dismiss. It wasn't appealed. There was a motion to re-argue. That was denied. It was then appealed. That appeal was withdrawn. And a new case was started. Rather than appeal the old case, a new case was started with the same operative facts, and that case was dismissed. The point I'm making is in opposing this appeal, in pursuing this appeal, I should say, the appellant is claiming he didn't get a full and fair opportunity to litigate the case. This appeal, the lower court dismissed on res judicata and collateral estoppel, and he did not appear for oral argument below. He did not appeal the first case, and now he's not present today. So I think his argument, among many other arguments that are in my papers, that he didn't have a full and fair opportunity to litigate any of his claims rings shallow in that respect. Any questions? That will be my argument.
Colleagues? Thank you very much, Mr. Hassman.
Thank you.
Victoria's Secret versus WTC Retail.
Mara Levin of Blank Rome for defendants appellant, new WTC Retail owners. Good afternoon. May it please the court. I will be referring to new WTC Retail owner as Westfield. Westfield is the ground lessee of the retail component of the World Trade Center complex. The case arises from Victoria's Secret's attempt to get out of a 100-page negotiated lease at the Westfield World Trade Center because of the delay in delivering the premises, despite a clear and
how long was that delay? 5 years?
Well, the lease was signed in 2015, but I want to point out to Your Honor that the trial court actually made a fundamental mistake when the trial court relied, two fundamental mistakes. One was that it read in a reasonable time standard, and two, it relied on Victoria's Secret argument, which is expressly contradicted by the lease.
Counsel, this is Judge Gonzalez. Hi.
I'm sorry.
It's okay. So this is a 10-year lease, right?
Yes.
And this action is commenced 4 years after signing because there's no estimated delivery date of the premises, right? And your argument is that there was no need to have an estimated delivery date because it's not written into the contract. Your argument is that the court overreached?
No. The argument is that there's a delay exculpatory clause which absolves Westfield from any delay in delivery. However,
no. But we're not talking about delay in delivery. We're talking about the estimated delivery date, which was never set. It was never scheduled.
Right. And the reason it wasn't scheduled was because of all the delays that the parties contemplated. It's important to note that there's no set dates for any delivery because the World Trade Center was under construction. This space is under the Performing Arts Center, which the Port Authority is constructing. Westfield is waiting for the Port Authority to deliver the premises to Westfield. The delay exculpatory clause was included precisely because the parties could not predict when the space would be delivered.
So what do you perceive as the estimate?
But the
how many years later? How many years after the signing of the lease?
The lease was signed in March of 2015, and the delivery notice was delivered in January of 2021. But that was because the parties knew it was in open and obvious construction at the time the lease was signed. In fact, what's important to note is at the time this was signed, Victoria's Secret also signed another lease. In that lease, there was a specific date for delivery or the lease would terminate. And in that lease, they negotiated a sunset clause, which they didn't put in this lease because this particular component of the World Trade Center complex was under open and obvious construction by the Port Authority.
How about the 270-day advance notice that was required once a delivery date had been set? Would 270 days have been a reasonable time to give an estimated delivery date?
If you look at the precise language of that section, Your Honor, the landlord is to give 270 days prior notice once it reasonably anticipates that it knows the delivery date will occur. So 270 days is reasonable.
This is Judge Owen. I got a practical question, and maybe it's just something that escapes me.
Okay.
You got a 10-year lease that started sometime. You have a 10-year lease, right? Did the plaintiff's obligation to pay rent ever accrue?
No, the lease term doesn't begin until the rental commencement date, which doesn't begin until there's been actual delivery of the premises to Victoria's Secret.
So you're saying that in January of 2021, you finally got Port Authority to give you the go-ahead, right? So You're telling me then that a 10-year lease, January 20, how many years would be left on that? Then it would be 4 years left, or you got another 10 years to go?
The lease term begins on the rental commencement date.
Okay, so that all right, I get it. Okay, so that nothing would happen until the actual, so they're not out of any money
Exactly. They haven't paid anything. They're not obligated to pay anything, and the lease term doesn't begin until it's delivered.
And you want to hold on to them as tenants. So isn't this like a couple that's engaged and they just hold on to the poor bride and the poor fiance, and they won't let her go?
Well, Judge Gonzalez, if Victoria's Secret wanted an outside date for delivery, they could have negotiated that, as they did in the lingerie lease. They could have negotiated.
When did
and
they
said,
wait? Hold on a second. The lingerie lease, was that entered into after this lease?
that lease was entered into a month before, and that
Before
is
this lease. Okay.
That's for a completely different part of the World Trade Center complex. And so
why are you bringing it up if it's for a different part of the complex?
I'm only bringing it up because of the Victoria's Secret, in its opposition brief, argues that the leases were related to one another, and there was an expectation that the lease for the beauty store, the subject premises here, would open on the grand opening date. But if I can point out, the court assumed the grand opening date was the date this lease was to begin, but the lease expressly states that the retail component is to open on the grand opening date, except for that space in Exhibit A4. And Exhibit A4 specifically exempts the Victoria's Secret space from the grand opening date, because that part of the complex was under construction by the Port Authority, and they were building, and they're still building, this big performing arts center. So nobody knew when it would be delivered. Victoria's
I'm
Secret
just looking, counsel, at a 1993 case from the Court of Appeals. Is it Savasta or Sarasta? That when the contract doesn't specify the time of performance, the law implies a reasonable time depending on the facts and circumstances of the case. Why wouldn't that apply here?
That doesn't apply here, Your Honor. And in fact, the court relied on a similar case from the First Department, because the delay exculpatory clause takes it out of that line of reasoning. When you negotiate a delay exculpatory clause, what you're saying is and this is what Westfield said in this case, we don't know when we can deliver the premises because we don't know when the Port Authority is going to deliver the premises to us. Victoria's Secret accepted that. They didn't require that there be an outside date for delivery. And by the court denying that the delay exculpatory clause applies to the actual delivery, but not to the estimated delivery date, it drew a distinction that simply doesn't make any sense, because the two dates are inextricably intertwined. The delivery notice contains an estimated delivery date, and the actual delivery is the delivery date. And there's a remedy.
We understand your arguments. You're way over your time. So let's hear from the other side. You'll have some rebuttal. Sorry. All right. Ms. McKinstry.
Good afternoon, Your Honors. I just wanted to briefly lead off in just correcting some things that were misstated regarding the record. So first, in response to one of the questions was, when does this lease commence? And section 1.02 of the lease, and this is the record at 29 as well as 39, states that the commencement date is the date the agreement was executed. That was back in March 31st, 2015. There is a subsequent rental commencement date. I'm sorry, Your Honor.
You don't agree that this lease would be 10 years from when you first commence paying rent?
I agree that it's 10 years from when you first start paying rent. I don't agree that the parties didn't have any obligations at the time of execution, because the lease expressly contemplates that it's the commencement date of the lease is when it was executed, and that's when the parties' obligations begin. The other thing I wanted to—
But you're not paying rent.
No. The rental commencement date does trigger that, but the parties weren't with that. This isn't a situation where the parties entered an agreement for some distance into the future they'll do something with respect to this space. It executed in 2015, and they estimated a grand opening date in 2015. Now, counsel also made reference to the delays that the parties contemplated. I just want to be clear with what was, or more appropriately wasn't, submitted in support. Landlord submitted an attorney affirmation that referenced 3 articles, and the articles generally discussed construction delays at the World Trade Center site since the September 11th attacks in 2001. And then they included in that affirmation a conclusory statement by their litigation counsel that said, quote, as a result of the delays, Port Authority has not delivered the premises to World Trade Center Retail. And that's at the record 14, paragraph 10. They did not submit any documentary evidence of what was specifically contemplated with respect to the construction at the time the parties entered into the lease. Nothing to support that the ongoing construction was what the parties contemplated at the lease. And just merely saying there's ongoing construction is not dispositive, because the lease expressly contemplates.
This is Judge Oing.
Sorry, Judge.
I'm trying to look at the practicality of this. It's just a commercial landlord-tenant situation here. You weren't paying any rent, correct? What's your downside other than the fact that you now waited 6 years now to the date saying, I'm still not in my shop? What's your downside in terms of, because your complaint basically, no, not basically, your complaint is, I want to get out of this contract. I want to get out of this lease. That's it, right? That's what your complaint is. And then for attorney's fees. But your cause of action or the relief you seek is the termination of this lease.
Correct.
So so I'm wondering, you know, practically speaking, were you out any monies? Because the fact of the matter is you weren't paying any rent. I mean, so the whole thing about this reasonable time of when you're supposed to be when they're supposed to tell you that the estimated delivery date, there's really wasn't a rush because you weren't paying any rent. It wasn't as if there was a specific date that rental will start paying. So why should we now agree with Supreme Court and say that there has to be at least some semblance of a time period for you to tell them what's the estimated delivery date when there's no negative implications there?
Well, respectfully, Your Honor, there is negative implications.
Okay, tell me.
As Victoria's Secret alleged in its complaint, it had a specific, retail moves, and they had a specific plan in place when they entered into this lease to have, this was supposed to be a Victoria's Secret beauty store. And as alleged in the complaint, it was supposed to help funnel the traffic with the way the World Trade Center is constructed to lead to a separate area where their lingerie store was. So they had a concept, this beauty, using it as a beacon store. It was a concept that was in existence at the time. This is the lingerie store.
This is the lingerie store we're talking about.
This was supposed to be a Victoria's Secret beauty store, and it's a concept that is now long dead and past. And then there's also money laid out associated with that. While they might not have paid rent, there's planning that goes into this. There's other work that tenant has to do with respect to the design. Exhibit B lays out all the things that Victoria's Secret had to put together with respect to that. So there has been an investment on behalf of Victoria's Secret. And like I said, it's alleged in the complaint and in the fact affidavit that this concept passed. But if I can just briefly go back to this idea that construction at the site is dispositive, it's not, because Section 6.04 of the lease, which is titled Landlord's Future Construction.
Let me stop you because
Sure, Your Honor.
You're coming towards the end of your time. This is a pleading motion. And
Correct.
So even if we're dealing with the idea of reasonableness, the question of what the construction may or may not be is somewhat irrelevant. It may go into factually determining the reasonableness of the timing of the delivery, but we don't get to that here, do we?
No, you don't.
Motion. So it doesn't matter. Maybe they put in their affidavits. They're either in admissible form or not, but we don't even get there, right?
Correct. You don't even get there.
Okay, we understand your argument. Let's see a rebuttal.
Thank you, Your Honor.
Okay. Thank you, Your Honor.
We're just moving along today. Go ahead.
I don't believe that there's been any material issue of fact that's been raised in order to sustain the breach of contract claim, because it's a heavy burden to overcome a delay exculpatory clause. They'd have to show that the construction was within the landlord's control, because the reasonable time standard isn't applicable under the line of cases.
Counsel, Section 503, which I believe is what you're referring to, shields your client from failure to deliver the premises. It doesn't say anything about failure to provide an estimated delivery date. Aren't you reading something into the contract that isn't there?
I don't believe so, Your Honor, because if you look at Section 1.02, it specifically states, and pragmatically speaking, as Judge Oing was saying, the delivery notice contains an estimated delivery date. That's that's the covenant or the obligation. And then the actual delivery, it has to be made within 18 months of that estimated delivery date, or else
I have
the
to
lease
stop you
automatically
for a minute.
terminates.
So,
Yes.
so if we read the contract the way you're saying, doesn't that mean that you never have to give an estimated delivery date? Well, what is your obligation to give an estimated delivery date? By when? If not within a reasonable time?
The obligation is by the precise language of section 102. Once Westfield reasonably anticipates the delivery date will occur, it is to give a delivery notice, which it shall endeavor to do 270 days before.
So suppose you don't act reasonably. Isn't that something that would be the subject of a breach of the agreement for failure to give an estimated delivery date? You haven't been reasonable in withholding it, right? Isn't that what we're talking about here?
I don't believe so, Your Honor. It's not the reasonableness of Westfield's conduct is not what's at issue. Once Westfield,
didn't you just read to me that you had to deliver an estimated date when you reasonably believed that you had a delivery date?
Right.
So if you're being unreasonable, you know that you can deliver and you just don't want to, and you don't give them a date. Isn't that a breach of contract?
The reasonable anticipation is this. If you look at what Westfield's obligation is, once it knows it's going to get the premises, it then does landlord's work.
No, but you're not answering my question. All right. Suppose it has all of the reasonableness. It reasonably believes that it knows when it can deliver, and notwithstanding that, it fails to give an estimated delivery date. Is that a breach of contract?
I believe that that there could be a breach if we reasonably anticipate. But I'd like to say that.
All right, last sentence. Go ahead, Ms. Lemon. Last sentence.
Thank you. But there's no issue here as to whether it anticipated being able to provide an estimated delivery date, because it hadn't even received the premises from the Port Authority. So until the Port Authority says this is when we're delivering the premises, it had no obligation to provide an estimated. It didn't arise.
But then we get into the issue of this is a pleading motion and you provided stuff that may or may not be admissible. Don't know. But okay, we understand your argument. Okay, thank you both. Thank you. Very challenging. Okay, international development versus Westchester Plaza.
Good afternoon, Your Honors. Would you like my appearance again, Your Honors?
Why not?
Okay. Edward Vincent with Fortune Spina on behalf of the defendant appellant. This is an appeal from a motion for summary judgment, which the lower court took one look at, and because of the length of it, just said issues of fact.
Don't do that. That doesn't help us. Go ahead, make your arguments. It doesn't.
My apologies, Your Honor. Understood, Your Honor.
Okay.
There's 14 different causes of action here, and the purpose of our motion for summary judgment was to pare down the issues for trial. Really, essentially, what this is a breach of a commercial lease argument, but there's many other causes of action that are presented, mainly fraudulent misrepresentation and fraudulent concealment, unjust enrichment, and other quasi-contract relief here. But what you have here is an arm's length transaction, which with lease revisions made by both parties' counsels during the negotiations. And then you have a ratification of the contract by initial rent payments. Although the respondent stopped making rents after several payments.
Counsel, I want to jump into this and push you onto a different track.
Okay.
So we know that the purpose of the lease was so that the premises could be used for a school facility, but also for any other lawful purpose, which kind of is broad, to say the least. But what the plaintiff appears to be saying is that you concealed information about all the violations that were extant on the building and with respect to the first floor tenants. So my question to you is this a question of fraud, fraudulent misrepresentation, or is it a question of breach of contract? And also, who had the responsibility of disclosing or investigating? Those are two totally different responsibilities as to the violations that were on the building that stopped the plaintiff from getting the certificate of occupancy for the school.
Yes, Your Honor. This property was taken as is pursuant to the contract, and the onus was placed on the tenant, the respondent, to take all of that. The certificate of occupancy at the time of the lease was an exhibit to the lease, and all of this is public record, including any violations that were against the property. All those are public record and able to be discovered by the respondent with any type of diligent inquiry here, but there was no diligent inquiry made. And even going past that, even if it was the burden for the appellant to disclose any such violations, which were alleged to be in existence, and I'll address that one in a second as well. There's specific contract clause that says there are no representations being made outside of this lease, and there is no clause within this lease that says any such representation regarding the status or condition of the property or violations on the property are being made by the appellant. Then you also have a lack of evidence in the record of any existing violations at the time that the lease was made. Specifically, and I have it in mine as well, specifically in the record as part of my motion for summary judgment, we attached the list of the Department of Buildings violations that were there at the time that we investigated this matter, and all of them were issued after more than 6 years after the entry into this lease. And the idea here was, of course, that the tenant, as is normal in these types of situations, would be developing the property. They received a 6-year rent abatement to allow them to develop the property and to allow them to incur that expense. And if for some reason they were not able to get their licensing, they were not able to get their certificate of occupancy to operate what was expected to be a school facility, of course, then they had the option to terminate that lease. And that's the key here, because basically what they've admitted to do is, well, we've put too much money into this property by developing it, so therefore now we're not going to opt out to terminate out of the lease. We want our money back. And so that's where you get into all the other quasi-contract relief, such as unjust enrichment, which the claim is that we developed the property, we're entitled to be reimbursed for the developments that we did to the property. But you have a contract. And the contract is very explicit as to what's supposed to happen. And what they're trying to couch everything else as, including the fraudulent misrepresentation and fraudulent concealment, is that, well, you agreed to perform certain of these repairs, which was to fix the roof and to put in $100,000 worth of structural repairs to the property, and that you didn't do that. And as a result,
and let me just stop you there, because you're out of time. If I could summarize, and in fact, an intent not to perform under a contract is not a fraudulent inducement, correct?
Exactly, Your Honor.
It's a breach of contract.
Yes.
And that's going forward, correct?
And I have no problem with that going forward to trial. I agree that there's issues of fact as to those issues. That was not the purpose of our motion.
All right, let's hear from your adversary. Thank you very much.
Thank you.
Mr. Schwartzberg?
Thank you. Respectfully disagree with the contentions of the appellant defendants insofar as the holding of the court by Justice Ruiz is appealed from should be affirmed. The decision correctly held that on the record there appears to be numerous questions of fact which remain, and I'll orally present what I think are the highlights. There are many. Paragraph 2A of the lease said that the school, the tenant, shall use and occupy for a school facility and any other lawful purpose. One of the contentions of the summary judgment motion was, well, you could use it now for some other purpose that doesn't require as high level of a requirement of approval from the not the Board of Regents, the State Department of Education and the New York City Department of Buildings. Well, the lease didn't say occupy it and use it as a school or some other lawful purpose. It said and any other lawful purpose. So it could have been a school plus a daycare center. It could have been a school plus something else, but not a discotheque or an office facility. In addition, the lease.
So what does that have to do with fraud?
Well,
I mean, I accept that's an issue of fact. Okay.
Well, if we move on to paragraph 4 of the lease, it says that the landlord shall be responsible to repair and restore to good order the roof. And this is where the problem remains to this day. The roof, as early as September 25th, 2006, as shown in the record, I think it's page 204, the landlord writes a letter barely 2 years after the signing of the lease that we're shifting the responsibility to you to fix the roof because.
And that would be, and let's assume that's fraud. Why isn't that a breach of contract? What's the fraud?
It's both, because the landlord didn't reveal what it knew, that the roof had 45 beams that needed work, replacement that is. It wasn't just a roof that had to be some tar put on it. It was essentially a sick baby of a building. And from 2006, where the landlord put in writing at the 204 is the record point, where the letter written by the landlord to the tenant, you fix the roof, it's your baby. As late as 2010, the engineers are fighting, and that's in the record, I believe pages 172 or 304. And the engineer of the tenant says, look, there are 24 things that have to be done, 1 through 24. And much of it stems from the roof problem, which would cost hundreds of thousands of dollars to fix because you didn't reveal what you knew about the roof. And the landlord at that point in time and the tenants say, you're to the landlord from the tenant, you're refusing to put the roof into good order. It's leaking all the way down to the cellar. It's causing violations in the stores. There are about 15 stores. And they say, the landlord says, you're going to fix the roof. And the tenant says, look, we'll do our best, but we don't know if this is something that we can do. And they get involved with trying to retain a roofer. And the cost is several $100,000. In fact, when it was last tallied sometime in 2017.
So counsel, was the tenant, was the defendant able to rescind the lease at that point? Could the tenant have backed out?
Well, the lease, as you know, ended in February of 2020. And at this point in time,
I'm saying the lease. So the lease was signed in 2004. So in 2006, in December of 2006, when the plaintiff is authorized to perform the roof repair and deducted as an abatement, you're saying that the tenant finds out, lo and behold, the cost is astronomical. Okay. So was the tenant able to back out of the lease and say enough is enough?
Well, at the point, I believe, within 6 years following the signing, which would bring it up to approximately 2010, yes, the tenant could have backed out. But by this point in time, they had
there's no rent being paid. Not until 2010 is there an obligation to pay rent. What's happening in this period is renovations, right?
Major construction, over $1 million. The school spent over $1 million at this point in time. But the structural repairs up to $100,000 weren't done either. But the main thing was the roof, because that involved 45 to be specific structural beams that had to be extracted and inserted and a roof put on top of it. It needed a whole new roof. And yes, to answer your question, the school could have backed out, but at that point in time, there was over $1 million of the school's capital, all of their capital at that, in the Bronx expansion project. As the brief shows, they were.
So is this fraud?
Well, what was fraudulent was the landlord not revealing what it would cost to fix the roof when the landlord said they're going to. What the landlord accuses in its brief the tenant of is what the landlord is in fact guilty of. The landlord did not properly evaluate how bad that roof was. The landlord probably, or quite obviously in retrospect, didn't know it was a $500,000 replacement job.
But counsel, when a tenant accepts a property as is, aren't you kind of gambling unless you do due diligence?
Well, they have no complaint except with regard to the structural repairs and the roof that the landlord made some feeble effort on until it found out what it would cost the landlord to fulfill the contract, and the Department of Building violations dealing with the issue of safety. Because it's a school, there were issues regarding, it was a general assembly quarters, and there were elements that had to be done because it's a school. So yes, the tenant could have backed out, but at that point in time, there would have been a lawsuit earlier. So the lawsuit began in 2011, I believe. It could have been begun in 2010, 9, 8, or 7, but the parties were squabbling. There was another attorney. We were brought in as trial counsel, and it is on the trial calendar. The reason for the delay.
The breach of contract. I'm going to ask you, Mr. Schwartzberg, just wrap up your argument because you're way over your time, please.
Yes. The wrap up is that the landlord has argued falsely that the tenant has been in occupancy for the past 15 years. That's not so. The tenant has not been in occupancy for 1 day. Make that 1 hour, except for the time that the executives and the engineers and the construction workers have been there, to the cost of the school of now 1.5 or 6 million. And at the point in time when Justice asked me that question about couldn't they have backed out, it was already at 1.1 million. So yes, we could have sued.
We understand. Right, that you had a lot of money sunk into the project by then, and you made a business decision not to. All right, let's hear from Mr. Vincent.
Not to sue.
All right, rebuttal. Mr. Vincent, rebuttal. You on mute? You're on mute.
I was, Your Honor. My apologies. Regarding the condition of the property, the argument is that the appellant misrepresented the status of the roof, but that's illogical because the appellant, according to the contract, was the one that was supposed to fix the roof. So whatever it was going to cost, even if it was going to cost extra, that would have been the appellant's responsibility. And to that end, of course, at some point during these issues, the appellant authorized the respondent to perform those repairs and included it as a rent abatement. And of course, they refused to do that as well. So what you have here is a situation where the appellant has refused to complete the renovations that they were needed and authorized to do, but then they want to turn around and claim that the appellant was the one that was responsible for this, and as a result, constructively evicted, or they even actually claim actually evicted the respondent from the property. But that's of course not the case. And as Judge Gonzalez indicated before, there was a termination option January 2008 during the rent abatement period, and so they had 4 years to figure out whether they were going to be able to do anything about this and then back out of the lease. But Your Honor, as Your Honor indicated, they made a business decision and they went forward with it, and now they're trying to claim fraud, unjust enrichment, but really it's just breach of contract. Thank you.
Thank you. We understand. Thank you. Thank you both. Thank you both. The next argument is Zubilis versus Degabi.
Good afternoon. If it please the court, Paul Gruber for Borough Goldstein for the appellants. At issue here is whether or not the court below erred in interpreting the continuous wrong doctrine. The facts, there are a lot of facts which I don't think are disputed here. Is that one, the defendants did do work on a driveway at various periods, and that the plaintiff's engineering and architectural report found that water is running off toward the western wall of the building. Whether this is a legal condition or not, anything, our client has alleged it does constitute a nuisance, and the case law is clear that running water can constitute a nuisance. It could also be negligence, and it could also be enjoined by a court of equity. The judge, I think, below misunderstood the continuing wrong doctrine. That allows the plaintiff to treat every incident, and this occurred only when there was a rainstorm or a snowstorm, as a separate event. It's creating a new cause of action.
This is Judge Gish. Is there any requirement that in order to get the benefit of the continuing wrong doctrine, that you have to show that the defendant or allege that the defendant was based upon defendant diverting surface water by artificial means, or that the claims or that the changes made to the plan weren't in good faith?
Well, as the record shows, there was at a time no building here, nothing here, a vacant lot. And then the defendants purchased the lot, and they installed a parking area and a driveway and a gate in various stages. Some work was 1989, the rest 2009.
When was the last time that work was done to the driveway?
In this record, it seems to say 2010. However, the inspection reports that the plaintiff obtained in 2015 and 2016 both show issues with respect to the pavers not being on grade, and that this could create an issue, which I don't think is resolved on the papers here, as to whether or not this altered the surface as to cause the water to run. Not saying necessarily. But when?
2009, when they were installed?
That is when, but that is when they were installed, 2009 or 2010. For purposes of our argument right now, I don't think that's critical.
Doesn't matter.
Right. However, it does still have the continuing effect, and the Court of Equity can deal with the continuing effect of this problem. This wasn't the land that was originally there when my client had purchased his home, and essentially our clients are elderly people, and every time they have a bad storm, they're experiencing damage to their property. There's a lot in this record about how they haven't repaired on their end. I think we could all agree that if we're talking about any kind of leak, you deal with the leak before you deal with the drywall or whatever. But I think on this record, the court, relied upon a third department case on a continuing, which didn't apply the continuing wrong doctrine. But there, the plaintiff stepped into an existing situation. The work had been done long before the plaintiff came in, and there's some due diligence.
Counsel, I'm going to just go back to my colleague's question. As to the improvements that were made, the surfacing of the driveway by installing pavers, are you calling the pavers? And I don't know, there's an echo, but I don't know. Are you calling the pavers an artificial means of diverting water?
I am not, that phrase hasn't been used in any of the paperwork in this case to date. I'm not going to start using it right now, but I'm just going to recite that the pavers, which weren't there before, before these defendants undertook their project, have resulted, at least according to the plaintiff's experts, in the water running toward the building and also causing some pooling in the area and a portion of the driveway, which also deviated west. So I'm saying there's a question of fact here.
Am I correct that that was done in 2009, the new pavers?
I think that was part of the 2009 renovation. I'm sure council would spend.
If I read things correctly, was the last act on their part that you allege?
That was the last act that that in this record, yes, they actually did to the property. There was talk about doing other things, but that hasn't occurred.
Generally speaking, Councilor, if I have it correct, the continuing wrong doctrine doesn't apply really to an effect. That an effect that keeps recurring doesn't create a continuing wrong.
And there have been holdings to that effect. However, we have Lapidus in this department where you had the constant trip of an air conditioner, which this court found was continuing wrong. Little more recently, earlier this year, Great Jones Studio, January case from this court. There was, long-standing work done on a adjacent roof, which caused an effect on another roof, which this court applied the two.
I think I was on that case, if I'm correct, and I think there were acts that were continually done, not just effects. I'm just trying to straighten it out in my own mind.
Understood. Right. I'll leave to the brief the issues about the renewal.
Your time is up, Mr. Gruber. Actually, way over. And we're going to hear from your adversary. I would also ask that all of those present on this virtual meeting of the Appellate Division, if you're not speaking, please turn yourself on mute, because we do have a bad echo that I think all of us are hearing. And if you put yourself on mute, I think you can eliminate that. So thank you. Unless, of course, when you're talking. All right, we'll hear now from Ms. Blumenhalf.
Blumenhalf, yes. May it please the court. Good afternoon, Your Honors. I represent respondents Dingara Gardingabe and Julie Camisuli. The court below correctly ruled that the appellant's case is barred by the statute of limitations and that the continuing wrong doctrine does not apply. Appellant's counsel is being purposely vague as to dates, but the dates here are very clear. Plaintiffs claim that defendants created a driveway on a previously overgrown lot in 1989, and they paved an additional portion of that unpaved carport in 2009. And they claim that that results in continuous water infiltration when it rains and snows. Those claims are clearly barred by the statute of limitations. The only question is whether the continuous wrong doctrine applies, and it doesn't. Plaintiffs documented water seepage problems
I think, excuse me, Judge Mazzarelli, I think counsel, in response to my exchange with him, indicated that the continuing effect is sufficient to extend the statute of limitations. I think that's what he was arguing, the dripping from an air conditioner, etc.
Well, the case law in the first department and actually the departments agree that the continuing effects do not continue the statute of limitation. It has to be continuous conduct. And in this case, the last conduct that's alleged and the last conduct that the last time the respondents touched the driveway was in 2009. That's the last injurious act, was the paving, alleged injurious act, was the paving of the lot in 2009. The law in this state is that the continuous effect, such as rainstorm, does not trigger the continuing wrong doctrine, only continuous conduct. And the only time that there is an exception to that is that if there's an encroachment, such as in the Bloomingdale's case, that would continue the statute of limitations. But here, there's no encroachment.
The Bloomingdale's case is the one with the water intrusion underground with the MGA, right?
With the pipe, yes, with the pipe that extends onto the other property, and there's nothing like that here. In fact, and the plaintiffs do not allege that the respondents intentionally diverted water. There's no encroachment. There's no artificial means of diverting water, and I have to correct the record.
Is there an issue with respect to the pitch, where the last 10 feet of the driveway pitch towards the wall of the plaintiff's building, according to their engineer? Does that change anything?
Well, actually, it does not. Their engineer said two things. They said that basically the driveway is flat from end to end. At the very last 10 feet, there's some slight pitch towards the building 429, then diverts down to the street. He found that the pitch was the same and consistent with the sidewalk, and especially when you have 4 minutes, a picture is worth 1,000 words. If you look on page 34 of the record, you'll see the driveway.
All the pictures, just so you know. I looked at the pictures.
Okay, so the driveway is flat from end to end. The house, 147th Street, is on a hill. So if there's any pitch, it's consistent with the pitch of the sidewalk, and you can see that in the picture. The house is on a hill. Nothing was changed as a result of the paving to the topography of the area. And in any event, and there's no evidence that it was changed. There's no expert, and there have been many experts on this property at this point. There's been no expert has said that the topography has changed, or that anything that the respondents should be doing to change the driveway would correct the problem for the plaintiffs, who really have to repair their wall. And as you know, it's well settled in this.
So if I may, so would that 10 feet worth of pitch, I don't know how, 10-foot length of pitch, would that constitute an artificial means of diverting water towards the plaintiff's property?
No, it wouldn't, Your Honor, because at that very spot, that's the very area where in 2006, the appellants requested access to go onto the respondent's property and correct their water intrusion that was affecting their wall. In fact, their entire wall since 1971 has been affected by water because it's unprotected ever since the city took the building down. But at that particular area, that's the one spot where the plaintiffs built a berm against their wall, which actually, ironically, diverts water onto 431, onto the driveway, or at least that was the intention, to divert water away from their wall. I assume the theory was that would protect their property when they also built a cement wall at that very spot to protect their property. When the defendants complained about that, their lawyer wrote them a letter and said, we really need this to protect our basement. This was in 2006, representing that they knew about the problem of water intrusion since 2006. And that's why the continuous wrong doctrine does not apply. Now, they are blaming
your time is up. So, and I think you've answered Judge Gonzalez's question. Is that true? Thank you. Okay. All right, so let's hear from Mr. Vaughn, rebuttal. Thank you.
Very, very briefly. The Lapidus case from this court with the dripping air conditioner, at least from reading the opinion in the decision, there's nothing to suggest that anyone did anything to change the installation of that air conditioner. It was in 1983, and the lawsuit wasn't until much, much, much later than that. I'd also like to point out at pages 100 and 174 in the record, there are notations with respect in the plaintiff's reports, the architect and the engineer, that the pavers were lower than the concrete slab, and that they are not sloped away from the western wall. Unless there are any further questions, I'd like to rest on the brief.
Anything, colleagues? Thank you both. EGR Realty against Stein.
Good afternoon, Your Honors. May it please the court. My name is Jean-Pierre Brutus. I'm an attorney at Bronx Legal Services, and I represent the appellate, Mr. Michael Stein, in this proceeding. The issue in this proceeding is whether Mr. Stein's apartment is subject to rent regulation as per RSL 26511C14.
So this is Judge Gish. Let me ask you a question to see, because we have limited time and I want to get to the crux of it. So
Yes,
you had a rent stabilization code provision in 2011 about how to calculate the threshold rent for luxury decontrol, correct?
Yes, Your Honor.
And then in 2015, there was a new statute that was passed, or a new rent stabilization code that was passed, and that provided for a different method for how to calculate the rent to get to the luxury decontrol threshold, right?
Yes, Your Honor. In
And what if it, we're going to get there, because I'm going to make this easy for you, because there's things we know, right? And the 2015 law made it easier for, or let me take that back, because it depends who you're looking at, made it harder for the landlord to meet that threshold, because the rent had to be at the threshold before the vacancy occurred. You couldn't apply, as in the 2011 law, you couldn't apply the vacancy increases to get to that threshold, right?
Well, yes, Your Honor. It's specifically for.
One more question, and then I'm going to get to the substantive, and I'll let you explain to me what is concerning me in this case. And so the 2015 law had a provision in it, and it said, you know, you guys, if you had a vacancy during 2011 and 2015, we're changing the way you calculated your threshold for luxury decontrol, and it should be harder for you to reach that threshold. That was a retroactive application of that law, correct? Because it was already 2015.
Well, Your Honor, I don't read it that way, Your Honor.
Okay, tell me why.
Well, first, Your Honor, the difference between the Rent Act of 2011 and 2015 is that the amendment in 2015 applies to a specific and narrow class of apartments where the tenant had paid a preferential rent and the legal regulated rent was
agreed.
Right?
Agreed, right.
It's specifically in reference to preferential rents. The statute has a language of prior to vacancy, saying that we look to the rent, the legal regulated rent, prior to the apartment being vacated. Right? It's a specific statute, not a general provision. The general provision remains the same. And when you have the general provision and the specific provision interpreting the same subject matter, the general provision must cede to the specific provision here.
But I'm actually was asking something different, because I agree with what you're saying. My question is, to the extent the 2015 statute was meant to apply to events that had occurred between the period of 2011 and 2015, wasn't that a retroactive application of that statute?
No, Your Honor, because the apartments are re-regulated subsequent to the effective date of the Rent Act from June 2015 onwards. The statute, the plain language reading of the statute, doesn't say those apartments are re-regulated between 2011 and 2015. It says those apartments that had been deregulated between 2011 and 2015 are now re-regulated subsequent to the effective date of the Rent Act.
Well, it doesn't specifically say that, but the interpretation that you want would in fact re-regulate apartments that had been deregulated under luxury decontrol.
Your Honor, I think the plain language reading of the statute does indicate that, Your Honor. It doesn't impose past regulation from the period between 2011 and 2015, as the Civil Court of Music Iowa noted. Yes, if the Court of Music Iowa noted there is a record.
So there could be no overcharge if in fact the apartment, as in this case, was deregulated under the laws as they existed in 2011, And under your scenario, it becomes re-regulated in 2015 so that any market rent that is charged between 2011 and 2015 is not an overcharge. Is that your
Yes,
position?
yes, Your Honor, that's exactly it. The apartments were deregulated during that period and remained deregulated during that period. There is no issue of imposing monetary liabilities for past conduct on landlords for that period of time. The question is about re-regulating the apartments, those specific class of apartments, subsequent to the effective date of the Rent Act from June 15, 2015 onwards, Your Honor. The application of the statute is prospective. It's simply bringing those apartments back under regulation. So that's
So you would have it that the apartment would be re-regulated in 2015.
Yes, Your Honor, exactly.
And going forward from there, and we would disregard the period prior to that. Is that correct?
Exactly, Your Honor. The apartment remained re-regulated for that period of time, but is brought back under regulation subsequent to June 2015.
I'm sure you're familiar with the Regina case, which relates to interpretation of a different statute. But how does that inform us in any way in our analysis here?
Well, I think, Your Honor, in this court in Montera pointed that we should be wary of applying Regina over broadly, right? Particularly if the case implicates re-regulating apartments, it doesn't implicate Regina. To the extent that this case does implicate Regina, this case is distinguishable from Regina on several issues. One, the Court of Appeals of Regina was concerned about imposing monetary liabilities for a vast indefinite period of time on landlords. That's simply not the case here. Here, there's no imposition of past monetary liability. The period of retroactivity is for a finite period of time from June 2011 to June 2015. And additionally, the application of the statute is prospective. Additionally,
this is Judge Owing, but just taking what you just said is very interesting in the argument that you're saying we're talking about apples and oranges here. We're talking about rent overcharges, which is not what you're arguing. You're talking about restoring a status to an apartment, right?
Exactly.
That's what we're looking for. Retroactive effect of restoring an apartment status. But isn't that in a way a form of punishment, or not punishment, but a form of sanction against the landlord, because they've had something that was properly deregulated, and now we're going to go back and changing it. And it's kind of like, I don't know, there's something doesn't sit well there. I mean, I understand your argument. You're saying I know there's a dichotomy there, but there's still an injury to the landlord, right?
Well, Your Honor, I disagree. There isn't an injury here with the landlord, Your Honor, because as Court in Regina held and in Montera, there's no vested property interest from individuals or property managers in rent regulation laws, right? Rent regulation laws change consistently. Additionally, Your Honor, this law is constitutional on due process grounds, right? Courts, both at the federal level and state level, have long upheld rent regulation laws on due process grounds and the rational basis test. Right. The burden here, Your Honor, is on BGR Realty to demonstrate that application of this law is an unreasonable exercise of the state's power that lacks a reasonable relationship to a legitimate legislative purpose. Simply put,
like a takings argument.
Exactly, Your Honor, like a takings argument here.
Well, not quite. Under Regina, actually, it's not necessarily a takings argument. It's a fundamental fairness due process argument about the retroactive effect of a rent law on whoever.
Well, Your Honor, in Regina, the court noted that it's crucial to look at, in terms of retroactive statute, to the effect that the statute is retroactive. In looking at the retroactive statute, it's crucial to look at the relationship between the finite or the retroactive period and the legislative purpose. The court in Regina,
that's right. Here it was a four years. I mean, yes. That's not insignificant. They were talking about in Regina, the periods that they were talking about, they said, yeah, sometimes you can do it, give a statute of retroactive effect if it's remedial and it's a few months and, but 4 years? 4 years.
Your Honor,
don't you think? You don't think. I'll accept that you don't think. Okay.
Well, Your Honor,
you don't agree. That was the wrong way to phrase it. That's all I know by that. I don't even know if I agree. I'm just testing it out.
There's one point I want to make, though. So we're talking about legislative purpose of the statute. It's to, I guess the legislature was trying to recover or maintain stock of affordable housing units, right? Oh, you're on mute. You're on mute. Ugh.
So thank you, Honor. So if I can go back to answering Judge Geisha's question as well as the question.
Professor's good. She's good.
Sorry.
Yeah.
So
That's a promotion.
Yeah, maybe so. I feel respected.
Thank you, Ron.
That's great.
So to answer both questions,
Yeah.
in regards to Regina, the court said we should look to whether the retroactive period is crucial to affecting legislative purpose. And here, legislative purpose is to maintain.
What's the end result? You're headed towards your answer is what's the end result? What are we looking, right? I mean, that's what we're looking at.
And here, preserving the affordable housing stock of previously rent-regulated apartments is particularly acute and particularly apt for tenants such as my client. My client is an elderly disabled grandfather who survives on a fixed income and lives with his 3 adult children who also live and survive on their fixed income, who are also disabled.
And that versus overcharge and penalties for other things. We're talking two separate spheres here, right?
Yes, and the court in Regina has called this policy goal a laudable policy goal, right? Particularly when you apply these kind of statutes prospectively.
Although to the particular provisions they were looking at, notwithstanding the laudable goal, they found that those particular provisions should not be given retroactive application.
Well, yes, because those particular statutes were imposing monetary liabilities for an indefinite period of time, as opposed to here where it's a prospective application of rent regulation, which there's a long-held tradition and precedent for both at the federal level and the state level.
Yeah, one other question though. When the 2015 law was passed, was there anything in the legislative history that otherwise indicated the laudable purpose for which they were changing the formula and re-regulating apartments and changing the formula by which you figured luxury decontrol for preferential rent apartments?
Well, Your Honor, I don't believe it's in the record here, but in an analogous case heard before this court, 191 Realty Associates versus Tejada, that language is in the legislative history. I believe there is some language speaking to the policy goals of preserving rent-stabilized housing stock.
Thank you. Interesting. Right. Mr. Gruber, right.
Yes. I would be remiss if I don't mention the mootness argument. I will not dwell on it. But after the appellate term ruled on this proceeding, the respondent consented to a judgment of possession. As for the reasons explained in the brief, we don't believe that mere reservation of a right to appeal in a stipulation creates the ability of this court to decide an academic issue.
Right, and the issue is, and maybe I didn't fully appreciate this until I heard the argument today, but there's no overcharge complaint. It's just the status of the apartment.
This is a status issue. In fact, the rents for this apartment, it would be below what the lawful regulated rent would be had the apartment remained subject to rent stabilization. And whether this illustrates or not, there are ways to create affordable housing outside of the strictures of rent stabilization. I'll leave that for others to judge.
But, right, that doesn't affect the case. But there is no, I just want to be clear, no overcharge.
There's no overcharge issue raised here. Yes. Right.
Are the Steins still in possession?
Yes, by virtue of a stay of this court, plus also the delays that came about through all the fun we've been having this past year. I'd like to point out something about the luxury deregulation principles here and why respondents interpret appellant's interpretation of the statute is just simply untenable and unintended. Luxury deregulation was first enacted in 1993. It was extended and modified in various ways in 1997, 2003, 2011, and 2015, and has been repealed in 2019. Now, in each of those renewals and extensions, the legislature played with the goalposts of deregulation, but at no point did they ever say that apartments that had been deregulated under a prior law was subject to regulation.
Well, let me stop you there. You know, true enough, the law doesn't specifically say that, but if that is not the intended effect, then how would the statute in 2015 otherwise be applied? When would it apply if not in those circumstances?
It would be applied to apartments which became vacant during the period that the 2015 law was in effect. That is, if you had an apartment that was rented in 2011 and the tenant was paying a preferential rent, and remember, and this is very important, a deregulated tenant doesn't pay a preferential rent, they pay a rent. If you had a tenant who would be paying a preferential rent and the math would bring that apartment over the deregulation threshold.
Can you just stop for 1 second? When you say a deregulated tenant doesn't pay preferential rent, you mean deregulated in the eyes of the landlord, or you mean someone who we know to be deregulated because of the
a tenant who has been lawfully deregulated? Let's not forget, Justice Gonzalez, that
echo. I'm sorry. Say that again.
I'm sorry. A deregulated tenant is a deregulated tenant. Let's not forget here that Mr. Stein is the second deregulated tenant of this apartment. This apartment had been deregulated earlier on while the 2011 law was in effect. And I think if I finish my answering the question that was posed before, it might clarify things a little more. What the amendment to C14 was supposed to do was if you took a tenant who had been paying a preferential rent, and that we all know is a term of art under rent regulation, during the course of the 2011-2015 law, and if for whatever reason the landlord's able to achieve that tenant, the next tenant's rent to go over $2,700, then that tenant wouldn't be deregulated if the prior tenant, stabilizing tenant, wasn't paying more than $2,700.
Mr. Gruber?
That's what it is. It's a prospective application.
Mr. Gruber, this is Judge Owings.
Yes.
So I have a question. My question is, so we're pretty much, I think, all on the same page, and even the appellant's counsel with respect to the retroactivity of overcharges and penalties. Just can't do that, right? Now, we're talking now specifically about, and I'm sorry for the echo. But we're talking now about the status of the apartment, whether or not it should go back to regulated status or continue as deregulated because it hit all the marks under whatever statute that was in play. So my question is that the whole thing about deregulating the apartment is a creature of statute. So if the legislature gives on the one hand, can't the legislature take it back?
The answer is yes, but they have to be clear. If you're going to apply a statute retroactively,
I got so many. There's so many volumes of appellate division reporters that shows us how clear the legislature is.
Right. I understand that it has kept us all in business and put our kids through school and all that stuff.
Business is good, even under COVID. It's good. But that's the point. I mean,
that's a discussion for.
And just listening to the appellant's argument is that this whole concept of deregulation, it's all creature of statute. I mean, it evolved from 2005 or 4 over the years, and now in 2019, the legislature said, you know what? We're going to, like you yourself said it, they moved the goalposts even more.
Yeah.
So why isn't that shouldn't be given retroactive effect and say we're going to recapture everything that we deregulated? We're going to recapture it now back.
No, there was certainly no intent about that. We certainly would have heard something about that in 2015. There's nothing in the legislative history that suggests that.
Well, I was
And
looking
in the
at 2019
2015
now.
law, and that went, I'm sorry, I didn't catch that.
I'm looking at 2019 now, because 2019 sort of
Right.
changed the landscape to everything.
Well, 2019 law, it's real simple. If this apartment was properly deregulated, then it stays that way. That's the cleanup bill. That's simple. But in 2015, the legislature did stick a little retroactive provision. It made the statute retroactive 8 days earlier to cover the gap between the expiration of the 2011 law and the 2015 law. That is clear. That is what the legislature did. They did not, through this sophistry, intend to re-regulate apartments that were lawfully deregulated under the 2011 statute.
So I have,
Is there any further questions?
yes, because I'm still concerned about, is this a retroactive provision or is it not? And in Regina, in defining what retroactivity is, the court said this: the statute has retroactive effect if it would impair the rights a party possessed when he acted, increase a party's liability for past conduct, or impose new duties with respect to transactions already completed, thus impacting substantive rights. Does this law fall any of those three circumstances that we need to do a retroactivity analysis?
I don't believe you have to do a retroactivity analysis here, but just to play the devil's advocate on this one, certainly the
you don't think
the rights.
Wait. You're telling me the statute has no retroactive component to it? It's nothing for us to consider?
Well, not this particular provision. As I previously noted, the legislature in the 2015 bill defined the scope of what was going to be retroactive. And it was basically, there wasn't going to be a gap in regulation.
Yeah, I understand, but I read your briefs and your arguments below, and there definitely was a substantive due process argument on the basis that this was a game changer after the fact.
I'm sorry, I just lost you. Yes, there's that argument too, and we also make the statutory analysis under 504.2 that the prior to language which got added on in the 2015 version wasn't applicable because wasn't in the 2011 law, right. And that under the principles of Altman, which construed very similar language, you could see the Ovadia case for that argument, that there was no legislative intention to deregulate what had already been lawfully deregulated.
Okay, thank you.
Okay,
Thank you.
And I think it's still a principle of the courts that if you don't have to reach the constitutional question, you don't.
All right. Thank you. Let's hear some rebuttal. Right. So now we could be thoroughly confused. Go ahead. Let me just ask you a question to start, because now I'm intrigued by this mootness doctrine. Is this moot? Is this moot?
Your Honor, no, it's not moot. My client continues to live in the apartment and he continues to pay use and occupancy. Or more aptly, my client preserved his right to appeal specifically on the issue of the regulatory status of the apartment, which, Your Honor, in the second department case at the appellate term, in Soleil, the tenant preserved the right to appeal, particularly on the issue of the regulatory status of the apartment. There is case law exactly on point on this issue. So one, this case is not moot, Your Honor. Two, Your Honor, BHR Realty's analysis of the statute would render ineffective and would be an impermissible statutory construction of the statute. The statute would not make sense with the reading that BHR Realty is advocating for. Your Honor, the whole point of the statute is to bring back those apartments that had been deregulated between 2011 and 2015 under rent regulation. This is not the first time.
The statute doesn't specifically say what Mr. Gruber's saying, but it doesn't specifically talk about recapturing apartments in rent regulation either. and it's a dilemma.
Your Honor, my reading of the statute, the plain language reading of the statute, that my reading and Mr. Stein's reading is that that's what happens with these apartments.
Because if it didn't happen, then that part of the statute would be meaningless. It's the only thing that could happen.
As the Civil Court in Music Iowa pointed out, the statute would not make any sense if it did not re-regulate those narrow classes of apartments. The statute would be without effect. Additionally, Your Honor, this is not the first time that the legislature has re-regulated apartments that had previously been deregulated or re-regulated a class of apartments. The foundational law of rent stabilization from 1974 re-regulated apartments that had previously been under rent control and that had been deregulated, Your Honor. So there is 50 years of foundational law on the regulation of apartments that had previously been deregulated. Your Honor, additionally, regarding 504.2 and Altman, 504.2 is not the controlling law in this case, Your Honor. That's not applicable. Altman interprets 504.2a, and as the court in Altman noted, 504.2a lacks the language of prior to that we find here in 511c14 under the Rent Act of 2015. Additionally, Your Honors, the court in Altman stated in a footnote that they were not interpreting the Rent Act of 2015. So their interpretation has nothing to do with this case. Also, Your Honor, Obadiah is not persuasive at all because the law there, the facts in that case were about a preferential rent and were similar to the facts here, yet the court decided to apply 504.2 and not 511c14, which makes Obadiah not persuasive in this case, Your Honor.
All right. Thank you. Thank you both.
Thank you, Your Honors.
Thank you.
Okay. We're going to hear the cases of Grunnett against ACNS and Dyer against ACAM.
Yes, good afternoon, Your Honors.
Give me 1 minute to just set up the timer. Not that it makes a difference, apparently, today. Okay, go ahead.
All right, may it please the court. My name is Justin Reinhart, and I represent American Built Right, Inc., the manufacturer of Antico brand floor tile. Now, American Built Right has appealed from denial of its summary judgment motions in the Grunnett and Dyer cases. Built Right moved for summary judgment based on causation, that its product, vinyl asbestos floor tile, did not and could not cause the plaintiff's lung cancers in those cases. Now, the guiding standard.
This is Judge Gish. On the issue of general causation, in each of these cases, did you make the same prima facie case? And by that, I mean, did you rely on the same experts who relied on the same studies in connection with the same product and the same disease, albeit different plaintiffs?
Yes, Your Honor. The experts and their foundational materials are the same for our prima facie case in both cases.
And did the plaintiffs in opposition rely on the same experts and studies and literature in trying to convince the court that there was an issue of fact?
Operatively, Your Honor, yes. The plaintiffs.
Okay, all right, well, good.
Okay.
I'm just trying to, all right. So would you agree that however we decide on the issue of general causation, that it should be consistent in both cases, or are there differences?
No, Your Honor, I would agree that they should be the same in both cases. And to speak to that a little bit, the guiding standard for evaluating expert opinions comes from the Court of Appeals decision in Parker. Now, that standard for evaluating expert causation opinions is a two-part analysis. The first being...
We understand. We're going to get to specific causation. We know all about Parker. We're going to get to it. You know, we're just trying to make sure that analytically we understand the general causation, and then we're going to get to the specific causation, which may or may not be the same because we have two different people here, right?
Yes, Your Honor. So for general causation, the Court of Appeals in Parker said, and I quote, "Whether benzene can cause AML is not in dispute. The question is whether gasoline with benzene as a component can cause AML." And the Court of Appeals in Parker said that after analyzing the plaintiff's experts' general causation evidence in that case. So here, whether chrysotile asbestos can cause lung cancer is not in dispute. The question is whether floor tile with chrysotile as a component can cause lung cancer. In other words, the plaintiff must establish that the levels of chrysotile potentially released from floor tile is capable of causing lung cancer. That is general causation. And there's not one single study that shows that floor tile can cause lung cancer, or that the levels of chrysotile fiber released from floor tile can cause lung cancer. Not one.
So you're saying, counsel, that there's no distinction between floor tile that's intact where the asbestos is encapsulated, as opposed to floor tile that's broken or cut, that it's simply floor tile across the board, has no relationship to lung cancer?
Your Honor, there's a study in the record of actual Amtico tiles here, which was cut and scored and snapped and broken. And no fiber was found released from that tile.
But you're expert though, right? That's part of your prima facie case.
Yes, Your Honor, but plaintiff has not challenged the methodologies or the findings of that study. And to answer your question, Judge Gonzalez, that's because floor tile is an encapsulated product. When floor tile is made, you put the vinyl, the plasticizers, and everything in this big mixer with the asbestos called a Banbury mixer. And it heats
No offense, I need to stop because isn't this besides the point? We're not talking about the encapsulated asbestos and floor tile. We're talking about the dust that's released in the process of otherwise installing floor tile. That's the crucial inquiry here, correct?
Yes, Your Honor, and that's where I was going with that. The dust just isn't released when you do those things to the floor tile. Imagine that you're baking a cake. Okay, you put your sugar in, you put your flour in, you mix it together, you put it in the oven, you pull the cake out and you cut it, you don't see a bunch of flour flying up into the air. The science is the very same and supports that analogy.
I don't know, Mr. Reinhardt, I'm not convinced.
Having made a lot of cakes, Mr. Reinhardt, I don't know that I fully agree with you.
Right, honestly, you know, but
you're talking
that's what you want to hang your hat on. Be my guest.
So the point is, though, we know the precise levels of fiber that are released when floor tile is manipulated, and there is no medical science that shows that those levels of fiber can cause lung cancer. There's none. And even if general causation is established, plaintiff must still establish specific causation.
Correct.
They have to do a comparative analysis in an accepted scientific methodology to show that the plaintiffs, here, Mr. Grunert, Mr. Dyer, had high enough doses of chrysotile from their alleged exposures to Amtico to have caused their lung cancers. Now, the Parker court said this can be done in a quantitative methodology or in a qualitative methodology, but plaintiffs' experts in these cases have not demonstrated specific causation.
Let me ask you another question, you know, because one of the things that Judge Mendez said is that it's your summary judgment motion. So, you know, if this was an argument that you were making to the jury after trial, okay, that might be something. But at this point, isn't it your burden to come forward affirmatively and prove no specific causation as to each of these individual plaintiffs before we get to whether the plaintiff can establish an issue of fact? That's the analysis, right?
You're absolutely right, Your Honor. And American Bill Right has made that prima facie showing on proper foundation that floor tile containing chrysotile cannot cause lung cancer and did not cause the plaintiff's lung cancer. And Bill Right did that through its certified industrial hygienist, Mr. John Spencer, who has shown that both Mr. Dyer and Mr. Grunert's dose from Amtico was in the range of background asbestos in the ambient air that we all breathe. Now, asbestos is a naturally occurring mineral. We all breathe it in every day. And the total that we breathe in over a lifetime is defined as dose in fiber cc years.
When you refer to dose as to each of these plaintiffs, you're referring to the formulations made by the defendant's consultant EPI, right?
Yes, Your Honor, but not only that. anytime all the epidemiology that addresses causation in asbestos exposures looks at a cumulative dose. And a cumulative dose is always represented in fiber cc years. So for example, nobody here says, nor will say, that asbestos in the ambient air can cause lung cancer. Plaintiff's expert in both of these cases, Dr. Ginsburg, cites to an EPA document for background asbestos in the ambient air that gives the very same high concentration as Mr. Spencer does. And he demonstrates that that concentration will equate to a lifetime cumulative dose of 0.31 fiber cc years. Now, by comparison, Mr. Dyer, who never installed floor tile, rather he was a salesman that alleged that he did cutting demonstrations for potential customers, had a dose of Amtico shown to be less than 0.0000033 fiber cc years, clearly several orders of magnitude below background. Now, Mr. Grunert did allegedly install Amtico, but only a handful of times. His potential dose is shown to be less than 0.000009 fiber cc years. Again, way below a cumulative dose at background. And that's assuming for Mr. Grunert that the tile he used even contained asbestos, which isn't supported in that record. In fact, he was unsure if he even used Amtico. Now, from Mr. Spencer's calculation of dose, the certified industrial hygienist.
What you're saying is that you established your prima facie case by relying on EPI's formulaic calculations with respect to the cumulative asbestos exposure of each of these people, right?
Not just that, Your Honor. Then American Bill Wright also relies on a pathologist, here Dr. Geyer. And Dr. Geyer then references the medical and scientific literature and studies to demonstrate that a dose in the range of 25 to 100 fiber cc years is required to deem asbestos the cause of lung cancer. Therefore, Mr. Dyer and Mr. Grunert's maximum potential exposure to chrysotile from Amtico could not be deemed a substantial contributing factor to their development of lung cancer. Now, plaintiff in turn primarily relies on Dr. Ginsburg in both cases. And Dr. Ginsburg's report suffers many flaws. First,
and I'm going to ask you, Mr. Ryan, not only in the interest of time, because I know how complicated these arguments are. Your time is up, so bring us to your point on the plaintiff's cases, and then we're going to hear from your adversary.
Yes, Your Honor. First, Dr. Ginsburg is a thoracic surgeon. Okay, he is not the proper expert to even evidence that fiber is released from floor tile, so he's not a certified industrial hygienist. But most importantly, and the key here, Dr. Ginsburg has failed to show that the amount of chrysotile potentially released from floor tile can be a substantial contributing factor to the development of lung cancer. Regarding causative levels, he simply opines that there's no safe minimum level. Now, setting aside foundation completely for a second, this statement alone does not meet the requirements of Parker. Stating that there's no safe minimum level is not the same as defining a causative level. As this court acknowledged in Juni, proof of risk, even an increased risk, does not constitute proof of causation. So Dr. Ginsburg here doesn't even define a causative level, which is required of him under Parker and its progeny. But even if he had properly articulated.
Come on, right, you're way over time. I have to wrap it up.
Your Honor, bottom line.
You'll have some time on rebuttal, Mr. Reinhardt. Hold that thought.
Okay, thank you.
Thank you.
Your Honor.
Go ahead, Mr. Golansky. You need to be off mute, though.
Thank you, Your Honor. Alani Golansky for the plaintiffs. Counsel says we know the precise levels of the fiber release from the tiles. Amtico's entire motion and every expert used in this case by Amtico, Mr. Pathologist Geyer, Pulmonologist Crapo, they all rely on one study by Mr. Spencer showing an incredible fiber release of 0.0000 whatever.
But maybe that's so, but so they rely on one study, and the study may have some flaws to it, and it may be biased because of who did it. But why wouldn't that otherwise just satisfy a prima facie case and turn it to you to come up with an issue of fact?
Yeah, I'm not going to argue that they did or didn't satisfy their prima facie case. I don't think they did, but it's clear that there's a question of fact because whereas Spencer has that study, that one study, not shown to be similar to these plaintiffs' use of the tile at all, Dr. Ginsburg points to 3 studies which involve the cutting and snapping of tiles, the exact same work that these plaintiffs did, and it satisfies the Parker standard of looking at similar studies. And he shows that cutting causes a release of 3 times above OSHA, nearly 0.3 fibers per cc. He says repacking, which is contact with the boxes in which they're contained, the tiles are contained and the dust is contained, causes nearly 1.0 fibers per cc. And then he has a 3rd study. Now, that means that Dr. Ginsburg's studies show fiber releases between 700 and 2,000 times higher than the one study conducted by the defendant's retained expert. So that alone, because it's so far above the OSHA standard, shows a question of fact on that issue. There's also a question of fact just based on the product specification, the tile itself. The tile is 18% asbestos if it's the vinyl asbestos tile. Mr. Dyer, however, also testified to working with the asphalt asbestos tile, which is 26% asbestos. And in Robey, for instance, the court pointed to the Sweberg study where the boiler material was 15%. Now, if there isn't the kind of transformation procedure, and there's nothing like that in this case that occurred in a case like Juni, then the dust is necessarily above 1%, which Robey said is sufficient to support, an expert opinion that that the exposure to the visible dust at least contributed to the plaintiff's asbestos disease. Now, in this case, let's look at Mr. Gruner testified to doing approximately 40 tile jobs in rooms, and he gave specific quantified dimensions of the rooms, which were up to 18 by more than 24 feet. So
let me stop you for a minute. Did Mr. Gruner, did he, in talking about working with tiles, did he identify the Amtico tiles, or did he just say tiles in general?
No, he identified Amtico. For instance, he even purchased the Amtico, so he knew Amtico. And if you the record at 70809 talks about his purchase of Amtico. He talks about the Amtico tiles being approximately 12 inches by 12 inches, 1 square foot. At 152 of the record.
That doesn't mean anything, right?
No, but he talked about his use specifically, and that's in our statement of facts. That's pretty clear. Both plaintiffs, and we would require that our plaintiffs either know or don't know that they used a specific defendant's product with frequency, regularity, and proximity, generating visible asbestos dust. And both did, and that's documented in our statement of facts. Now, if the tiles, as Mr. Gruner said, were 12 by 12, the Amtico tiles, and if the rooms were 18 by more than 24, then each room is approximately 500 square feet. And if he did the 40 to 50 jobs, then he's laying and cutting and snapping and scraping over 20,000 Amtico tiles and breathing in the dust.
I want to just go back to Judge Gish's question. So would it be accurate to say that Mr. Gruner equivocated about which tiles he was using? Because there was a question, wasn't there, in the record at 170? Do you recall an instance when you purchased Amtico tile and he said no? And how many occasions did you pick up Amtico floor tiles from any particular store when where it was to be installed by yourself? And the answer was no. And do you recall, didn't he have difficulty with identifying the tile?
I would think he would. He was born in 1925. He was 90 years old when he was testifying, and his and some of his testimony is self-contradictory. He doesn't recall things at one point, and he recalls things at another. But
so what do we do with that, counsel?
Well, on a summary judgment motion, the credibility is not adjudicated, and if he testifies sufficiently to allow an inference in his favor that he used the Amtico tiles, which clearly this testimony was replete with that sort of testimony as well, then he has to receive the benefit of that inference, as Justice Mendez rightly held.
Mr. Golansky, you gave us a particular site to the reference where you believe that he identified the Amtico tile. Could you give that to us again, please?
Well, in my argument notes, I have him purchasing the Amtico tile firsthand at 70809 of the record. Customers requested Amtico tiles by name, and he worked with them. 170, 708, 713 to 15.
What, are you going too fast?
Yeah, you're going too fast. We really are writing this down.
170 of the record, 708 of the record, 713 through 15 of the record. All of this floor tile contained asbestos, 718 of the record. And he said for all of the Amtico tile that he installed, those tiles contained asbestos, 173 of the record. And I'm just really right now just reading from my brief, so at page 5 and 6 and thereabouts. And what he says about Amtico and his use and handling and cutting of Amtico is there, documented there. Now, Spencer gives no protocols for his study. He doesn't say how he conducted his study or why it could have been sufficiently similar to the either of the plaintiff's work, but he does say that he relies on a 1979 Navy statement, which is a one-page statement involving a flint coat tile study, which said that we don't believe at this time that the personnel using the flint coat tile or installing it are in danger. But what he ignores...
Doesn't that go to weight? That's weight.
Yes,
right?
that goes to weight.
Okay.
That goes to weight.
So that's not summary judgment stuff, right?
Yeah, but what is summary judgment stuff is that there's a 1998 flint coat tile study in both records, 1173 of the Dyer record and 816 of the Brunet record, which relies on the same tile type, flint coat tile, and shows that the fiber release was 13.85 fibers per cc, which is 31,000 times above the amount of fiber release cited by Mr. Spencer. So these are factual issues all over the place. Now, in this court,
I'm going to ask you to wrap it up.
Okay. The last thing I'll say is that in this court's decision in Nemeth, where the court credited the expert's statement that the fiber release from the particular product was above ambient air, Mr. Ginsburg says that the fiber release from the asbestos tiles was exponentially greater than the ambient level of exposure, which is the same statement, nearly verbatim, but even in a stronger wording than the expert gave in the Nemeth study.
Well, the experts in Nemeth said more than that. They had done recreations from a heritage sample of, in that case, it was talcum powder, to determine the fiber release, right?
Yeah, no, of course
Yeah,
they
it's
said
different.
more, but these are all statements that this court cited as being highly significant. The one last thing I'll say is that for all of this doubt about Mr. Gruner, Spencer, in his dose reconstruction, which is a totally dubious methodology, credited Mr. Gruner with 27 times higher exposure to Amtico asbestos dust than he credited Dyer. He you know, the 000s, if you look at them and divide the one by the other, Gruner's is 27 times higher than Dyer, and that's on page 271 of Gruner, and comparing it to 213
I think the only
of
question
Dyer.
there, counsel, is the connection to Amtico tile. That's the issue.
Okay,
Because it's very clear that the 50.9 is greater than the other one, the 331.
If it's just a question of product identification, I think my statement of facts will address that.
Thank you. And let's
Thank
hear
you.
from Mr. Reinhardt. Go ahead, you have 3 minutes.
Thank you, Your Honors. Just to briefly address the facts of Gruner. Not only did he say he wasn't sure that he ever installed Amtico, and that's in the record on appeal at page 162. He also said he didn't know if it contained asbestos. He never saw any Amtico product marked with the word asbestos or the name vinyl asbestos tile on the package, and so that gives an indication that the tile he used was not asbestos containing, because Amtico made both vinyl asbestos containing tile and non-asbestos containing tile. And here, Mr. Gruner speculated that he did floor tile installations, including Amtico, from 1950 to 1979. Amtico didn't even start making vinyl asbestos tile until 1961. And this all goes to the crux of American Built Right's entire motion for summary judgment here, is that plaintiff's expert does not have a foundation to support a causation opinion. So in addition to the lack of a scientific foundation that's present in both cases, Dyer and Gruner, in Gruner, you've got this factual foundation issue where Mr. Gruner never even establishes, nor is it established by any other evidence, that the tile he used, the Amtico tile, he may or may not have used, even contained asbestos. So Dr. Ginsburg has to speculate that the tile contained asbestos to then give a causation opinion, which he's not entitled to do. Now, plaintiff said that Mr. Spencer only relies on a single study. And that's just simply not true. He does calculate Mr. Dyer and Mr. Gruner's
But he
dose.
otherwise conceded that that's sufficient for a prima facie case. So I don't think it's really worth that much time in terms of argument.
Okay. Well, to address
we're only deciding a summary judgment motion.
Then to address Dr. Ginsburg's the work practice studies that he cited to. Now, the highest fiber release that he gives for floor tile, and you'll see in his report, is 0.96 fiber cc's from a study that's otherwise incomparable to what the plaintiffs here did. But still, taking that highest number, we put in the record the deposition of the technician that did that study. And they said on an 8-hour time-weighted average, that number becomes 0.016 fiber cc's, which is below the OSHA PEL of 0.1 fiber
It's not
cc's.
a trial, though. This is not right. You're arguing, both of you, arguing a lot of weight arguments.
Well, Your Honor.
I understand. I'm going to ask you to finish up.
Yeah.
I know these are
Having made
very
our prima facie
complicated
case.
issues. We have
Sure.
a lot of them today. Go ahead.
Having made our prima facie case, we shift the burden to the plaintiff to then present their
We
evidence.
understand that too.
Their evidence does not create a question of fact because they've got these levels of fiber release and then not a single medical scientific article that says that that level's causative. So their ultimate causation opinion is not based on proper foundation. It's a question of foundation. So for example,
You don't have to give us examples. We understand the argument. No more cake baking, Mr. Reinhardt. You're out of time. Okay? No,
Thank you,
honestly,
Your Honor.
we have your briefs and the record on appeal, and we really do understand how complicated these issues are. And I appreciate the nature of the argument. Thank you both.
Thank you.
Thank you, Your Honors.
Okay, People versus Rivas.
May it please the court, I am Vatsala Sahai from White & Case. Together with Legal Aid Society, I am pro bono counsel for the appellant Grilzon Rivas. Mr. Rivas's conviction should be set aside because the Allen charge that the trial court issued in this case was coercive. The Allen charge reminded the jurors of a preset deadline that was set to expire within a few hours of the charge being
If I may,
issued.
Counselor, before we get to analyzing the nature of the Allen charge, how did you preserve your objection to the language of that charge?
Your Honor, our objection is preserved because the trial court did not preview to counsel that it was going to issue a modified Allen charge. The trial court told the counsel that it was going to issue a standard charge and then deviated from that. And
but did you object to that? And did you take an objection to the courts doing that?
Your Honor, no, we do not object to that at trial, but that objection would also not have served any purpose because the jurors had already been informed of the deadline. And so the coercive impact of the charge had already been imparted to the jurors. The case I would most rely on in this is the Court of Appeals decision in People versus Orama. And I wanted to quote from
Orama is a mode of proceedings case where there's no actual preservation necessary if the objection is to something that is characterized as a mode of proceedings. And I don't know that that applies here. You were given an opportunity here to object to the language of the Allen charge. And yet, as far as I could see, there was no such objection lodged.
Your Honor, I would say that People versus Orama, even if not directly on point, is definitely very instructive in this behalf. And there is some language from the decision which I would want to quote that a trial court should ordinarily apprise counsel of the substance of the responsive instruction it intends to give, so that the counsel can seek whatever modifications are deemed appropriate before, in emphasis, the jury is exposed to the potentially harmful information, end quote. And I think that is exactly what happened here. In Orama, the court did not consult with counsel before it issued an Allen charge. And similarly, in this case, the court told counsel that it was going to issue a standard charge and then issued a modified Allen charge.
Could the modification, though, if an objection had been made, been ameliorated in front of the jury? In other words, your objection is not that there was a hard stop on this trial, which everybody knew about, but that the court didn't make it clear that you could either reach a verdict or not reach a verdict by then. Either alternative was okay. And couldn't the court have said that had an objection been made when the offending language, if it was offending, was made below, the modification, as you call it? Couldn't it have been cured or ameliorated?
Your Honor, at most it would not have been ameliorated, but it would not have been cured. The overwhelming purpose of an Allen charge is to try and have the jury, is to try and potentially break a deadlock amongst the jury. And at that point, the jury is...
If possible, right? If possible, give it the old college try. That's what it's for, right? Believe me, we've all given them. Everybody sitting, everybody here before, we have given Allen charges.
Your Honor.
And the whole point of preservation is not to trick someone. It's to give the court just what Justice Gish was referring to. It's to give the court the opportunity to ameliorate a mistake or to correct a mistake before it becomes a serious error in the trial.
Your Honor, yes, trial counsel could have preserved it at trial by objecting, but the fact that trial counsel did not does not mean that this issue is not preserved because of the fact that the court did not preview to counsel. And there have been cases like in the third department, People versus McGuire as well, where when the court did not consult with counsel, a preservation to the Allen charge was preserved, an objection. And in either scenario, this court has routinely heard unpreserved objections to add-in charges just because of the sensitive nature of a charge. And in this case, as the justices have already noted, not only did the court remind the jurors of the deadline, but it did not tell the jurors the consequences of deliberating beyond the deadline. The impression that the jurors had was one that they really had to try and reach a verdict, and they had to do it within 3 hours, and that is what happened.
But counsel, here, didn't you have an extension of the time at which the trial would ordinarily close? Didn't this go to 6 o'clock? And didn't this go to 6 o'clock at the request of the jurors? How does that factor into your argument?
Your Honor, yes, it did go beyond the 4:30 p.m. deadline that the court had originally set, but that extension only happened because at 3 p.m. the jury returned a note seeking some readback of testimony. And once again, the court reminded the jurors of the deadline and said that I'm going to read you back this testimony, but this is going to take us beyond 4:30 p.m. So let me know your schedule. And at that point, the jurors gave her a different schedule. Still, at that point also, the trial court had the opportunity to remind the jurors that it was okay if they did not arrive at a verdict by 4:30 p.m. or at 6:30 p.m. and the trial court did not. So the impression that the jurors are still getting is that they need to arrive at a verdict and they need to do it soon.
Okay. All right. Let's hear from your adversary. Ms. McLaughlin.
May it please the court. Good afternoon. My name is Megan McLaughlin and I represent the people. Now, I just want to start by first addressing, as this court has pointed out, this claim has not been preserved for this court's review. At no point during the proceedings below did defendant object to any part of the Allen charge after the court gave it. And this case is much more analogous to People v. Williams, which was a decision by the Court of Appeals in 2011, and People versus Gonzalez, given by this court in 2019.
Well, suppose an objection was made. What would have been the cure? How could it have been cured?
At that point, if there was any offending language, as this court has mentioned, to even correct in the first place, at that point, the judge might have been able to instruct the jury and clarify any offending language that the defendant had brought to the court's attention.
Like what? Like what? What could the judge have said to undo I guess the undoing is the impression. Your adversary is arguing that they were left with the impression that because of the hard stop, they had to, in order to get out, they had to come up with a verdict.
Yes, Your Honor. And that is where the issue lies, because there was really nothing to correct. The jury never should have had the impression that they needed to come to a verdict, because the court throughout its initial instruction, as well as during the Allen charge, never indicated that the jury had to come to a verdict. In fact, the judge was very clear that any verdict had to be a unanimous one. With respect to the initial charge, the court made clear to the jury that no juror should surrender an honest view of the evidence simply because he or she wanted the trial to end or felt outvoted. And then when the jury indicated it was deadlocked, the judge gave the Allen charge, which essentially tracked the model charge. And in that instruction,
nobody's objecting to the CJI charge. You know, it was the additional language.
Yes, and in regard to that additional language, because the Allen charge essentially tracked the CJR charge, there was no reason for the jury to believe that when they were reminded that the deliberations would last till the end of the day, there was no reason that the jury should have believed or would have believed that that deadline, quote unquote, would require them to reach a verdict when they had been reminded throughout the trial, additionally within the Allen charge, that they did not need to come to a verdict. The judge even said in the Allen charge that they should stick to their guns if no change in position was appropriate. And when she did impose or remind them of this deadline, her next sentence indicated that they would wait, all the parties, her, the attorneys, would wait for whatever response the jury had for them. So it was very clear in all of the judge's instructions that there was no requirement to reach a verdict and that simply deliberations couldn't go past that day, which this court has already pointed out was not a set deadline. There was no 4 o'clock, you need to finish. It was, we need to finish by today, but we will wait for whatever you have for us, which the jury then turned around and indicated, we're willing to stay here till 6 o'clock. We will, and in their notes, they indicated that they wanted more substantive evidence. And then they indicated at 5:30 p.m. that they had come to a unanimous verdict. So all of the judge's instructions taken together and the totality of the circumstances indicate that no reasonable juror would have taken these instructions and believed that they needed to surrender their conscientiously held beliefs in order to reach a verdict. And for these reasons, the charge was not balanced, or was balanced and not coercive.
You understood what you meant, right? Okay. All right. Thank you. All right, Ms. Are you done? I'm sorry.
Oh, yes, Your Honor.
Okay.
If there's no further questions, I rest on.
Any questions, colleagues?
Yes. Are you going to address the excessive sentence argument that the defendant is making? Could you just do that briefly?
Yes, Your Honor. This defendant brought 2 armed men into his family home, and he was essentially armed. He had brought 2 men into his home, one with a gun, one with a knife. He actually had instructed the gunman to shoot his stepfather when his stepfather wasn't complying with one of the men. And then this defendant proceeded to attempt to enter the room that they were attempting to rob. And in this case, the trial judge was in an excellent position or the sentencing judge was in an excellent position to determine an appropriate sentence since she had been the trial judge. And since this defendant was facing anywhere from 3.5 to 15 years, the sentencing court's sentence was appropriate.
Okay. Ms. Sahay, rebuttal, 2 minutes.
Yes, thank you, Your Honor. First, on the sentence, my client was not armed, and this is something which the state also admits. We also request this court to reduce the sentence in interest of justice, given the several mitigating factors. His young age, he was barely 19, yet hardly a criminal record. He started getting into trouble a few months before this incident, which consisted of 2 non-violent misdemeanors. He's not a habitual offender or a hardened criminal. He's somebody, a troubled individual who's grown up under very difficult circumstances. We think his sentence should be reduced. Second, on the Allen charge, counsel said that when the court reminded the jury of the deadline, she again stressed that the verdict need not be unanimous, that they need not arrive at a verdict. In fact, the court did not do that. The court reminds the jury of the deadline, and the next sentence is, also, if you feel that you've reached a verdict on 1 or more counts, you can let us know that as well. We will wait for whatever response you have here for us. So again, the jury is getting the impression that they need that first, there's an onus on them to provide a response by the deadline, and that response should ideally be a unanimous verdict on 1 or more counts, and which is what happened here.
Okay, thank you. Thank you both. Ms. Sahay, I understand that you're serving pro bono, and I'd like to thank you for your service. And please convey to your law firm our thanks for letting us have you this afternoon.
Thank you. Yeah.
American Empire versus L&G.
Yes, good afternoon, Your Honors. May it please the court. My name is Maureen O'Connor, and I represent the appellant American Empire in this matter. The issue here is an insurer's remedy for the insured's failure to comply with a premium audit. What this appeal comes down to is the lower court's misapplication of sections of New York insurance regulations to American Empire, specifically 11 NYCRR 16110, Section 23, and Section 3426. American Empire is an excess line insurer, and the excess line policies American Empire issued to the L&G defendants are...
So Ms. O'Connor, I have a question for you. If that provision doesn't apply because your company was an unauthorized excess insurer, where do we look for the rights of the parties? Do we look to the insurance contract itself?
Yes, Your Honor.
So under the insurance contract, what is the remedy for a failure to comply with an audit requirement? Is it a condition precedent to coverage or not?
Your Honor, we submit that compliance with the audit is a condition to coverage under the policy, as well as payment of the premium.
How could it be a condition precedent Well, there was a payment of a premium. There was a substantial payment that was made at the beginning of the policy, right?
Yes, these.
And then it was subject to audit at the end of a year based on receivables because the calculation of the premium was based on the receivables, right?
Yes.
And the receivables, depending upon the audit, there could either be additional premium owed or there could be a refund, correct?
Yes.
So can you really say that the audit was a condition precedent to coverage? There had been coverage all year. Why would you have to wait until the end of a year where there was a true up for the coverage to otherwise be effective? How does that make any sense conceptually or contractually under this policy?
Well, because American Empire's exposure is based upon the amount of business that construction contractors do in the city of New York. The contractors estimate before the policy period begins how much work they're going to do. If they say they do $1 million of business, they pay a premium based on the $1 million of business.
Counsel, actually, can I interrupt you for 1 second, though? When you say exposure, the policy limits are what they are, right? Pursuant to the contract, pursuant to your policy of insurance? Or you're telling me that that's left blank? There's no policy cap?
The policy limits are per occurrence. The number of occurrences is directly dependent upon how much business the contractor does. If the contractor does $30 million in business,
I get that. So that, but the audit just means it's an after the fact. I mean, if something happens during the policy period, regardless of whether or not, I mean, your audit's coming at the end of the year. So if there's an accident that happens during the policy period, how does that argument really fly then? What you're just making the argument about how we need to know because, the number of occurrences, it affects our exposure. This audit's happening at the end of the year when everything is done. The claim could have arose on day 2 of the policy.
but the claims are usually not made, sometimes they're made during the policy period, but very often they're not paid. They're made until 3 years after, within 3 years after.
Only in this case, that happens to be the circumstance. But if a claim was made on day 2 of the policy, could you really legitimately say here, we're not paying until there's an audit at the end of the year? You couldn't do that. It's not a condition precedent to coverage.
In fact, American Empire takes a position, it's a condition precedent to continued coverage. The fact that the insured has not complied with these conditions on an ongoing basis. American Empire here is not.
But the coverage period is already elapsed. It's not that it isn't an obligation. I get it. And it's not that there may not be remedies. There may be. What I don't understand is the argument that it's a condition precedent to coverage. How can it be? How can it conceptually be?
Because if the insured's premium is not paid, American Empire is forced to provide coverage to the insured, which wasn't paid for, which wasn't part of the bargain for.
Well, some of it was, and maybe it all was. We don't know. There was no audit.
That's exactly what the problem is. The insured could have done 30 times as much work as they represented before the policy, and the only way.
Or 20 times less.
Yes.
But the counsel, you're seeking a default judgment vitiating the policy. In other words, basically terminating ab initio, saying that this policy never went into effect. That's the declaration you're seeking on default. And as Justice Gish is pointing out, how does this really work out? Because you're making arguments that sound like, if we had gotten our audit, we would have gotten our exposure. But like Justice Gish says, they put $250,000 down already. That may have been overpayment. So I don't see how you can ask as a remedy a default judgment to vitiate the policy, which the policy, a binder's been issued in this case, in this policy. You've got a coverage there. If you're owed money in terms of premiums, that's a separate claim that you can make after the fact. I mean, you have insurance coverage there. The claims got to be, someone's got to defend and indemnify those claims. If you're owed money, at some point, yeah, I mean, you got to say, look, we got to get paid. Assuming that that's accurate, that's a separate action saying you owe us X amount of dollars. you know, for payment.
American Empire is not looking to void the policy ab initio. There, in fact, were claims that were defended and paid under these policies. We are not looking to, American Empire is not looking to get paid back for those claims. They're not looking for any declaration as far as what has already occurred, but they're looking for declarations on an ongoing basis based on the insured's failure to comply with their end of the bargain.
Well, you can terminate their contract. You can terminate the policy going forward. I mean, I don't think you can terminate. I mean, I'm sure there's language in the policy saying, you know, going forward, the insurance carrier has a right to provide notice and saying, you know what, we're terminating your policy, you know, on 30 days notice, something like that. I mean, that's not, I mean, I can understand why you want to get out of this insurance contract. And I think there are remedies for that, right?
There would not be a remedy going forward because we're not looking to terminate any future coverage. We're looking for declaration of no coverage for this specific policy for which they didn't pay premium. So, you know, the remedy.
Again, I take issue with didn't pay premiums. They certainly paid money. Maybe it wasn't a full premium. Maybe it was too much. But we understand your argument. So let's hear from Mega Contracting.
May it please the court, Brian Forbes. I'm actually on behalf of St. Augustine. We had worked out an agreement on what parts
You're going to go
discuss.
first? All right, we can live with that. Go ahead.
All right.
You answered the other way. That's why I thought you were. Never mind. Go ahead.
Thank you, Your Honor. I just want to point out here, they're not arguing void amnestiato, and they're not pointing to any case law that would ever allow that, because the only cases that they cite to that deal with void amnestiato are obviously those material misrepresentations and trying to take out a policy, which is a fraud argument. So that's not applicable here. So I want to turn to the non-cooperation argument that is in their paper.
But the point is they're looking to terminate the policy, right? That's what they want. This action is a termination of policy.
Yes and no. It's been unclear throughout the papers whether they're seeking to actually terminate the policy or they're seeking a declaration of non-coverage. They flip-flopped about what exactly they're seeking. And
either way you put it, you're arguing, wait a minute, I got coverage. I'm an additional insured.
Absolutely. That is absolutely our argument. And we've asserted all along that under the separation of insureds doctrine, for any of the non-cooperation arguments would not apply to St. Augustine or Mega Contracting as additional insureds. They accepted tenders without reservation in both the Grubb and Pacheco underlying actions. So there's really no argument there that we are additional insured, and a named insured's lack of cooperation doesn't apply to an additional insured due to the separation of insureds doctrine. And their policy actually sets forth the separation of insureds doctrine because it has a separation of insureds clause in it. It's on page 81 of the record. So we think that those arguments don't apply to us. But the other issue we have is we don't want coverage vitiated to the named insured either, because we have valid contractual indemnity claims that might come into play down the road against her named insured. And in that regard, we don't think a non-cooperation argument even applies in this case to the named insured, because non-cooperation requires three things that haven't even been pled in the complaint here. Why
would we even reach that issue? I mean, the insured is not here. They're MIA. Not only are they not here, but there's a bankruptcy. I don't know that we could go against them. The trustee maybe has to be here, but I just, maybe you're right, maybe you're wrong. I just don't even see how we reach it.
And that's a reasonable conclusion, Your Honor, because
good hint there for you.
Thanks.
It was not necessarily even argued by American Empire at the underlying, which was something we pointed out. And we had pointed out in our papers that there's just no basis for them to seek non-coverage against any of the defendants here. Their remedies is essentially a compelling a premium audit and potentially a debt collection action if they find out that they were actually owed anything.
Or maybe a future cancellation of the policy, depending on the time they could have canceled it prospectively, but not after the claims were made.
Absolutely. And they actually put in their policy, there is a cancellation form in the policy, and it provides for 10 days notice of a cancellation for non-payment of a premium, 30 days notice of cancellation for any other reason. And that's on page 63 of the record.
Well, this is kind of like non-payment of a premium, right?
I would say,
I guess kind of, sort of, right.
But where it's ambiguous, it's construed against American Empire. So
Well,
I think that's
right. But the policy hasn't been canceled, so it's not even an issue. You made your claims, the policy wasn't canceled.
That's correct.
They didn't exercise that remedy. The question is that they're raising, is it a condition precedent? I'm having trouble with that conceptually, but okay.
In your cross appeals, you're arguing you're entitled to attorney's fees.
Yes, and I was going to let my co-counsel address that. I did want to raise one more point just to make it clear here. I think stepping back and looking at this from a distance too is important. Her named insureds, American Empire's named insureds, went out of business right towards the end of this policy period. I don't know what date they requested the premium audit because the affidavit they submitted from Mr. Myers doesn't give a date when they even requested this premium audit. So what happens is you get two claims in New York State against supposedly a New Jersey insured with a New Jersey insurer. And they, at some unconfirmed date, requested a premium audit to a business that's no longer in operation. And then,
well, is it in bankruptcy?
The sole principal of the named insured was in bankruptcy, and it was something that we looked up, and we have the bankruptcy filing number. The actual company itself never filed for bankruptcy.
Yeah.
So what
just
they're doing
MIA, yeah.
What they're doing here is, if this is a pure debt collection action, why is it in New York? Why is it against the additional insureds as parties? Why were we brought in with the summons of the complaint? It calls into question
well, I can answer that, but I'm not going to. It's right. You're the one that they'll have to owe money to, and they believe they have a position that would let them off the hook in paying money. Would say that they're not obligated. That's why we're here. But all right, we'll leave it at that. Let's hear from your co-respondent appellant.
Good afternoon, and may it please the court. I'm Allison Drachman, counsel for Respondent Cross Appellant Mega Contracting Group. As was just mentioned, I was going to be handling the attorney fees issue. It's our position that lower court erred in failing to award Mega and St. Augustine reimbursement of the attorney fees. It never would have incurred but for the insurer having sued it. The facts of this case fit squarely within the exception to the American rule put forth by the Court of Appeals. The American rule states that each party bears its own legal fees where an insurer advances a claim against an insured, but the exception recognized by the Court of Appeals in Mighty Midgets and explained in City Club makes clear that an insured who is cast in a defensive posture by the legal steps an insurer takes in an effort to free itself from its policy obligations and who prevails on the merits may recover attorney fees in the defending action. The court below was legally wrong to distinguish the well-accepted findings of Mighty Midgets and City Club, and it was factually wrong to suggest that Mega and St. Augustine were not cast in a defensive posture by having to appear to litigate this case. Mega was placed in a defensive posture because it was named as a defendant in a coverage lawsuit commenced by the insurer that sought a declaratory judgment that it had no duty to defend or indemnify its insured. It was forced to engage coverage counsel and to litigate until the rights and obligations of the party were decided by summary judgment. Mega prevailed on the merits, as did St. Augustine, and the plaintiff didn't appeal that. It's irrelevant that American Empire subsequently withdrew a portion of its motion that sought relief against Mega. The fact that they retreated from certain—
Well, that didn't change really anything that was really before the court, right?
Right, that's our position.
I mean, still had to, otherwise the court had to make a decision about the underlying coverage, and that affected the additional insureds as well, even though they withdrew the motion as to you. They didn't withdraw the case.
Exactly. It was only the order of Justice Bannon that resolved the claims of the insurer against Mega and St. Augustine, not the withdrawal of the points.
So your claim is basically that regardless of the withdrawal, you were still placed in a defensive posture in this.
Exactly.
Okay.
Exactly. And for those reasons, we think that the exception would apply here. And what the trial court suggested that a statute or agreement was necessary to award attorney fees. We think that's incorrect under the facts here, because, we were placed in the defensive posture. And but for the insurer's suit, Mega and St. Augustine would not have incurred these fees.
Thank you. All right. All right, let's hear from Ms. O'Connor. You have 1 minute, please.
You're on mute.
Yes, unmute yourself.
Okay.
Good.
Sorry
You're
about
just
that.
no, you don't have to
that
apologize.
didn't
We're
count
living in a different world.
That didn't count off my minute, did it? Sorry.
No, it does not. Go ahead.
American
But
Empire
don't go
is not.
over.
I'm sorry?
I said, but don't go over.
Okay. Well, don't I get 2 minutes because I have two respondents?
No, you can't.
American Empire is not looking for a declaration of no coverage as to Mega and St. Augustine. We have said that repeatedly from the beginning, but apparently counsel and Mega and St. Augustine ignored that from the beginning. What American Empire is looking for, and I believe that there was a motion filed by Alani, the Excess Line Association.
Counsel, your adversaries are seeking attorney's fees because, but for this litigation, they wouldn't have had to pay anything to defend.
That's it. But American Empire paid their defense in the underlying case and did not withdraw any defense and is not looking to recover anything from them. This action will not affect any of the underlying.
What exactly are you seeking to do?
American Empire is seeking a declaration, first and most importantly, that these sections of the insurance regulations cited by the lower court do not apply to excess line insurers as a whole. I believe there was an amicus motion filed by Alani because the overreaching effect of the lower court applying insurance regulation, which does not apply to excess line insurers, is great. Their legislature specifically carved out from these sections of the insurance law their applicability to excess line insurers. And as far as Mighty Midgets applying here, the lower court correctly found that Mighty Midgets holds that an insurer's responsibility to defend reaches the defense of actions arising out of the occurrence. American Empire did defend these entities with their occurrences. This is a contractual issue between American Empire and its insureds. The LNG defendants are the insured. Mega and St. Augustine chose to expand the scope of this litigation by filing a cross appeals. We were not looking for
Ms.
any.
O'Connor, you have exceeded 2 minutes.
I apologize.
Okay.
So American Empire respectfully requests that this court issue an order declaring that the cited sections of the insurance regulations do not apply to excess line insurers, and that American Empire is entitled to a declaration of no coverage for the LNG defendant for ongoing claims and not for any claims that it has already defended or paid.
All right, Mr. Forbes, 1 minute.
As to the insurance law sections, I just want to point out that those arguments were never raised in the court below. At no point was even the allegation made that American Empire was an excess lines insurer. The court below's decision does not find globally that those insurance law provisions apply to an excess lines insurer in the state. They were never made at the court below. There was no evidence submitted on the record on appeal that
It wouldn't matter if the contract otherwise supported your position, though, right?
And that's the second part. Even if these insurance law provisions do not apply to American Empire, they have pointed to no factual basis, meaning the contract language of the policy, or legal basis for a declaration of non-coverage, not only as to the additional insureds, but also as to their own named insured. They have not put forth any basis for that. And this is a insurance policy subject to the regular interpretation of policies that we use in both this state and New Jersey.
Understood.
It's construed against the drafter.
Okay.
And I'll rest on my papers from
Thank
there.
you. Ms. Strackman, 1 minute.
Thank you. They're trying to say, American Empire is trying to say that it doesn't arise out of the occurrence because it was dealing with a contractual issue, but that's not the case. They sued, St. Augustine and Mega seeking a declaratory
Just a
judgment
question.
action in the dispute
Stop.
of whether they
This
had
is important to you because even if they're not looking to get back their defense costs, they don't want to pay any claim when the underlying litigation is resolved, right?
Yeah.
I mean, if you're liable, they don't want to pay it. And they would otherwise be bound under the insurance policy to pay it because you're additional insureds. That's what's at stake here, right?
Yes, very much so, Your Honor.
Okay. All right. Yeah. Any further questions, colleagues? All right. Thank you
Thank
all.
you.
Thank you, Your Honor.
Okay. People versus Saladin.
Good afternoon. I'm Ray Koshetz. I represent Mr. Saladin. May I begin?
You may. You're on mute. You're on mute.
Huh.
Yeah.
Can you hear me now?
Yeah.
You can.
I see. Okay. I'm sorry. Mr. Saladin was a New York City police officer for 17 years. During all of those years, he worked patrol in public housing without a single substantiated complaint. He was offered a violation, not even a crime, and no jail time if he pleaded guilty in a plea bargain. He turned that plea bargain down. He was found guilty after a bench trial, and now he is sentenced to 9 months in jail. We are appealing on the grounds that the assault charges against him relied on video footage that was not dispositive and on the testimony of two witnesses whose credibility was severely flawed, and that the people were unable to disprove his defensive justification in this case. There's also a claim that Mr. Saladin, and there was a conviction for deliberately falsifying two reports. He immediately and fully admitted that he had used physical force in a struggle with the complainant, and the evidence does not justify a holding that he deliberately falsified any report with the necessary intent. We further argue that defense counsel at trial was grossly ineffective because there was no valid strategic reason not to explore the motive of Mr. Saladin's partner to give extremely damaging testimony against him when she herself had pending internal disciplinary charges. And I say again, a jail sentence for someone of Mr. Saladin's age, he's now more than 50 years old, with his previous fine record of service, is unduly harsh. He suffered the loss of his career and the public shame of a felony conviction that severely impacts his life in the future. Those are the principal claims.
Thank you. Any questions, colleagues? All right. Can we hear from the people? Ms. Cohn?
May it please the court, Beth Fish Cohen for the people. This was an unjustified assault against a prisoner who was lying face down on the floor with his hands cuffed behind him. The defendant punched the prisoner in the face so many times that his own partner grabbed his arm and told him that it was enough. And then just 14 minutes later, defendant again resumed his attack against a 19-year-old mentally ill individual. He led him to an isolated back stairwell out of the sight of his supervisors and fellow officers and punched him in the ribs. Then he went on in several police reports as an experienced officer who was well aware of what he was saying in those reports and tried to defraud the police department into believing that the use of force had been justified or and non-excessive. The defendant deserved the sentence he got, as the trial court noted. This crime was qualitatively different and distinctly egregious based on the fact that he not only victimized this individual, but the effect it has on the entire city and the police department. If the court has no questions, I believe I responded to at least most of the points that counsel raised. If there's nothing, I will rest on my brief.
Any questions, colleagues? Okay. All right, we'll hear on rebuttal. Ms. Koschetz?
Yes. First of all, there was justification in this case. The complainant was acting like a lunatic, was actively and violently resisting arrest with, frankly, very little help from his partner. Yes, he always admitted, he never denied.
The charges here, Counselor, are that he was subdued at the time that he was attacked. He'd been
Absolutely
subdued.
not.
He'd been handcuffed.
Well, let me address that. First of all, yes, he was handcuffed, but he had attempted to bite the officer. He was moving his legs. He was trying to trip Officer Saladin. He was actively resisting all the way. Yes, Officer Saladin said, I punched him. It lasted just a few seconds. It can be seen on tape. And he had the right to defend himself against being bitten and injured by this man who had a history of violence.
This is Judge Gish. The trial judge, though, said that there were punching incidents both before and after the threat of a bite. Does that impact the issue of justification?
It would if it were true.
Well,
but
that's
it's not.
what the trial judge found.
It's
There's no basis in the record for the trial judge to have made those factual findings?
I believe so, because you can review it and you can look at it. He was dealing with a guy here who had just, even beginning, he was banging his head against a wall. Once he was handcuffed, he continued actively resisting. Officer Saladin didn't shoot him, really didn't choke him. And really, what's interesting to me also is that there was never a medical record introduced or any medical testimony of any kind. Officers may use reasonable force, and our argument here is that reasonable force was used and that the people did not disprove that beyond a reasonable doubt. And we have to ask, what is a cop supposed to do when he's faced with this kind of situation? This man never became compliant. And he was just about all alone. He had a partner with him, but she really was not doing very much at all. Another very important thing to point out here is that the defense counsel at trial never asked her a single question about her pending disciplinary case. And he never even suggested that perhaps her claiming that she told my client to stop as she was standing there was related to the fact that her disciplinary case had not been adjudicated yet. So she had a real motive that should have been explored to a fairly well on cross-examination, and as to why she was doing this. Not only that, but there was an attempted assault charge leveled for an injury that not even the complainant claimed. And the only witness on that was this female partner who said it, not even the fellow who was supposedly being kicked in the ribs. So,
okay. You want to wrap up, please? Yeah. Thank you. Thank you both. Okay, final argument of the day, Lee versus Tiedemann.
Good afternoon, Your Honors. May it please the court, my name is Eric Fishman, and I represent the appellants. Your Honors, we filed this appeal because the lower court erred when it declined to compel the parties to arbitration, even though the only contract governing the parties' relationship contains what courts have referred to as the paradigm of broad arbitration provisions. As just a brief background, the respondents in this action are hedge fund managers, sophisticated individuals. And in 2018, they and their lawyers negotiated and executed.
That's Mr. Fishman. So that's the whole question, is that, you know, they went into business with the defendants, right? Or the respondents. And then later on, there was another triple agreement or something that put everything together and said, you know what, that first agreement that we had originally got together on, you know what, that's gone. That's by the wayside. We're going to have a new agreement governing our relationship. But the problem is that, at least the argument that I'm hearing, is that their complaint or their claims arise out of that first agreement in terms of how they were sharing their profits and everything, correct? And that's what they're arguing, that's why it's not subject to arbitration.
That's correct, Justice Owing.
Right.
The argument in that is that the arbitration provision that's in the 2018 agreement,
right,
which superseded and replaced that 2012 agreement, does not relate back to issues occurring prior to 2018. And that's just not the law. That's not the law. There are two main issues in this case. The first is whether the lower court should have even decided that issue of arbitrability.
The gateway issue, as they call it.
The gateway issue, and the lower court misstated the law. And I think both parties would agree that the lower court misstated the law. What the lower court did is said, because the arbitration provision did not specifically refer questions of arbitrability to an arbitrator, that the court was permitted to decide questions of arbitrability. But that's not the law. The law in this jurisdiction and in Delaware is that when there's a broad arbitration provision, such as the one we have here, which relates to any disputes or disagreements among the parties, and also confers upon an arbitrator the right to...
It ropes in jams. It ropes in jams, saying jams rules apply.
Exactly. And there's the Skyline Steel case in the First Department that specifically referred to an arbitration provision that included jams. And they said when the parties...
Jams is smart. Jam says, you know, you pick us, we're it for everything.
if you pick us, we get to decide what's arbitrable and what's not. And
you guys can still fight over it, but we're the ones, right?
we're the arbitrators. We decide what issues are arbitrable or not, and that's precisely the clause we have here. And whether it's under New York law or Delaware law, it was incumbent upon the trial court to refer these issues to an arbitrator. The lower court should have never decided that issue. We shouldn't be here. And so that was the first manifest error. The second goes more to your point, Justice Owing, and that's retroactivity. And the federal courts in New York have spoken on this exact issue. And they say that absent a temporal limitation, specifically in the arbitration provision, such that the parties make it clear that the arbitration provision only applies prospectively, that absent that temporal limitation, those clauses apply retroactively.
Well, that's if we get to that, right? If we don't get past the gateway, we don't get to the next issue, correct?
If you get to gateway, which is the seminal issue in this case, you don't need to get to the second issue of retroactivity. But assuming that the lower court was able to rule on issues of arbitrability, which I think was incorrect, the next issue is whether that clause should apply to conduct prior to the date the arbitration provision was executed. And there are cases that are exactly on point in the Second Circuit, where there's an agreement that was executed, and the question was whether it applied to the previous to conduct occurring before that agreement was executed. And the courts in the Second Circuit were construing the same clause that we see in our case, a broad clause like ours, the same precise language, and they have held that the provision applies retroactively. And so there are a lot of other issues involved, but to just put it as succinctly as possible, I know this has been a long day. The first issue is the gateway issue. That was wrong. The second issue is a retroactivity issue. And again, the lower court got it wrong because it should have applied the clause retroactively, specifically because, as you say, Justice Owing, that 2018 agreement that contains the arbitration provision, that specifically superseded and replaced that previous agreement. Not only it wasn't a boilerplate provision.
Mr. Fishman, I need you to, your time is over. You need to wrap it up. So when I hear not only, you made your point, make your final point, and then we're going to hear from Mr. Taylor. It's been a long day.
It's tough to keep it.
Sorry.
Yeah.
He had a cup of coffee before he got on the screen.
I had a few M&Ms to get my energy up, but the only thing
I
say is,
like in person better when we have the red lights. At least you know it's coming.
The only thing I want to say is that that 2018 agreement specifically says that the 2012 agreement that Justice Owing referred to is no longer a force in effect. So the respondents can't even sue on that agreement because they released all claims. I'll rest my.
Thank you. All right, Mr. Taylor, you're up.
Hi, thank you. Good afternoon. So before the gateway issue of arbitrability, who it is who decides arbitration, there's a question of choice of law. And the contract clearly says that Delaware law governs the enforcement and interpretation of the contract. The issues that the court has in front of it are all questions of contract interpretation that are governed by Delaware law, which is significant because Delaware law differs from New York law. Mr. Fishman's arguments are all made under New York law. So to start with the gateway issue of arbitrability, under Delaware law, a court must. It is a must. It's mandatory.
Mr. Taylor, that may be true, but Delaware law, there's got to be a proviso saying unless the parties agree, otherwise agree, right? I mean, although Delaware law says gateway issues are to be decided by the court, there has to be, I'm almost certain, the court's going to say unless the parties agreed otherwise.
Right. Absolutely. Absolutely. It's an issue of contract interpretation.
Right.
So, and that goes to the retroactivity question. Right.
Well, it goes to first now the gateway issue now, because if we look at this contract and look at it and say,
okay, so I'll take that up first. Okay. So what Delaware law says, Delaware law as a general rule does not. It has an opposite inference that if a contract doesn't explicitly say it's retroactive, it is not retroactive. So for federal circuit court cases who have applied that same presumption in the context of an arbitration clause has held that this arbitration agreement that says any claims arising under in connection with this agreement,
excuse me,
that does not have retroactive effect.
Hello, this is Judge Mazzarelli, but don't we have a situation here where the contract incorporates the rules of JAMS, which mandates the...
No, Your Honor, if I may, with all due respect, that's not Delaware law. Delaware law has follows the same rule.
Yeah, I understand that, but I thought that there was a contract here that the parties had entered into, which did apply Delaware law, but also incorporated the rules of JAMS, with
yes.
a broad arbitration clause incorporating the rules of JAMS. And the rules of JAMS provide for the arbitrability to be decided by the arbitrator.
That's absolutely correct. Absolutely correct.
So why doesn't that lead us to the conclusion that the issue of arbitrability goes to the arbitrator?
Because Delaware has a different rule than New York. Under Delaware law, where there is a broad arbitration clause that incorporates the rules of an entity like JAMS that gives arbitrability to the arbitrators, a contract like that, which is at issue here, there are two exceptions where the judge nonetheless must, it's mandatory under Delaware law, make an initial review of whether or not there is any non-frivolous argument for the application of the arbitration clause. There are two exceptions under Delaware law that do not exist under New York law. Mr. Fishman acknowledges that in his briefing. He just says those exceptions don't apply here.
Oh, wait a second, Mr. Taylor. You're saying that under Delaware, the no non-frivolous argument. I always got that That's a tongue twister. That's a tongue twister there. Basically, you got to have, if you don't have a real argument for arbitration, you're not going to go to arbitration. That's
Exactly.
Are you arguing then in this case here that the claims that your clients are asserting, they're not subject to arbitration? Because
Exactly.
that's basically it, right?
Exactly.
How can that be? Because you're arguing your claims are breach of fiduciary duty. Your claims are arising out of the fact that they skimmed money from you guys when you guys were all together, and you should have been sharing profits in a nice way.
Yep.
So how is that not subject to arbitration?
So let me. There are two answers to that. First, I want to address the gateway issue, and the ruling below. The judge found, and this is in the transcript in the record at page 20, that he could decide in a nanosecond, that this retroactivity argument that Mr. Fishman is making is wrong. So that's the gateway issue. Let me go to
Mr. Taylor. Then I'm misconstruing this whole concept. The gateway, to me, the gateway issue incorporates everything. So I got to decide, or we have to decide right now, whether or not the retroactivity and all these claims go before an arbitrator to decide whether or not it's arbitrable. The exception the Delaware courts have laid out with respect to this, the court decides initially about arbitration unless the parties agree otherwise. And then the Delaware courts carved out another exception that says that if there is a real argument that the claim should not go to arbitration, then it won't go to arbitration. Okay? So now I'm at that third level.
Excellent. I'm with you.
The third level is, are the claims that you're asserting in this action not arbitrable?
Absolutely.
And how do we get to say, how do we say they are?
Yeah. Okay. So just the facts, right? The defendants are the managing members of a limited liability company. Under Delaware law, there are default fiduciary duties that managing members of limited liability companies owe to non-managing members. So as of 2012, defendants owed fiduciary duties to my clients. So I just want to read this into the record because Mr. Fishman is erroneous in his briefing. This is what Mr. Fishman says in his briefs. Appellees incorrectly claim the fiduciary duties arise from common law. He also says fiduciary duties arise out of operating agreements. The rights of members and duties owed by fiduciaries are set out in various provisions of an operating agreement. Please be patient, please.
It's been a long day. I'm not signing it because you argue. I'm just signing because I'm tired.
Okay, but that's wrong. That's wrong. That there are default fiduciary duties, just like officers and directors of a company have fiduciary duties to shareholders and partners owe fiduciary duties to other partners. As a matter of Delaware common law, managing members of limited liability companies owe fiduciary duties to non-managing members. And I'll give you a citation for that.
But that's not necessary.
Okay.
Don't give us a citation because we'll accept that for the purposes of your argument right now. And we will check up on it as soon as we are done with this argument today.
What you just described is so quintessential in terms of what arbitrators do when it comes to commercial disputes. My best example is something that's not a real. Please bear with me for a minute. But my best example of something that's not subject to arbitration is the punch in the nose situation. If you punch somebody in the nose, that's not subject to arbitration because that's not going to be part of this whole scheme in terms of doing business. That's a tort.
Okay, so
that is a situation where no, that's not arbitrable. Out.
Okay, this is a tort too. These are torts that occurred years before they entered into the Trinity agreements. You understand that? There are fiduciary duties that they owe years.
I'm going to chime in here. There are torts that arise out of the business relationship. In the absence of a business relationship, there would be no duties. So that is different than the obviously non-frivolous argument that my colleague is making, Justice Owing, about punch in the nose. There's nothing about the business relationship that would create duties regarding not to assault and batter somebody.
Right. So under that business relationship that existed between 2012 and 2019, there was no obligation to arbitrate. Nobody agreed to arbitrate during that time period. In 2019, a new contract was entered into that included an arbitration clause. Every federal court that has looked at an arbitration clause that's the same has said that that is not retroactive.
But here's the problem with not giving that issue to the arbitrator, okay, is that you are not looking at it for frivolity. That is the substantive contractual argument that is at the core of their business relationship and their contracts. So if in fact your claim that this would fall under the no non-frivolity, it would swallow the rule. It would swallow the rule. It would have the court in all circumstances look at the substantive issues that are seeking to be raised in arbitration and make a substantive determination about them before they can go to arbitration. That can't be.
Okay, so let me respond to that. What is the
That's going to be the end of your argument. We're responding to my question.
Okay, what is the non-frivolous argument that Mr. Fishman's making? Right, Mr. Fishman is citing to federal common law in the Second Circuit to say that a provision like that, like the arbitration agreement, has retroactive effect. That's his argument. Right now, under Delaware law, there is an opposite presumption. Under Delaware law, an arbitration clause does not have retroactive effect unless it expressly says it has retroactive effect.
I understand that's your argument, and that's the same argument you'd make in arbitration. That's not the same. I just don't see it as the same thing. But I respect what you're saying, Mr. Taylor.
May I finish?
No, honestly, it's a long day. We understand your arguments. Maybe we agree with them, maybe not. Mr. Fishman, you have 2 minutes, no more than that.
I have nothing further, Your Honors, unless you have any questions for me.
Any questions, colleagues? Okay, I appreciate your patience for waiting such a long day to be heard. And I gave you time in this non-enumerated appeal because you do raise significant issues, and we will take a serious look at them.
Thank you very much.
Thank you.
Read the papers.
Yeah. Of course, we're going to read the papers.
All right, thank you.
Mr. Taylor. All right. Thank you all. This session of the Appellate Division is now closed.